here and want to make sure everything runs smoothly.
I am happy to stand by. I have things to read. Attorney Pattis, I checked 5 minutes ago. Anything on, were you planning on just arguing or?
Yes,
that's fine. I just want, because I checked right before I came out and I wanted to make sure.
You know, I've spent my time writing with respect to our motion at the close of the plaintiff's case. Attorney Sterling and I made some progress on the verdict form, and we may reach an agreement on ascertainable loss later in the day. I'm not sure if needs to be argued right this minute.
I leave that up to you.
Okay.
Were you able to put your heads together on the language that I'm going to tell the jury about Mr. Jones?
Yes, Your Honor. Our view is that the court, it's not necessary for the court to do that Mr. Jones made his own decisions, asked the court originally to say something to the jury. However, if the court is inclined, we did reach an agreement on language.
We did.
And which is?
I don't, may I check my
Absolutely.
I don't have it printed out. I didn't see it until I arrived in court this morning.
Again, if I hadn't mentioned to them at both your, I guess it was an agreement that he was going to testify, I wouldn't feel the need to say anything, but that's what I promised them, and so I think it perhaps should be addressed.
I'm more or less of Attorney Maddie's mind, but
All right, then,
I defer to you on the grounds that
if you both agree, it's not something that you're going to address yourself, Attorney Pattis, when you rest. So if we're just going to remain silent upon it, and whatever you're going to do in closing argument is a different story.
The only reason, talking out of both sides of my mouth, what else is new? The only reason that I can see that would lead me to prefer you say something is so that there's absolutely no need for me to even nod in that direction in closing arguments, because almost anything I say would be inappropriate. And so I think it might be helpful for the court to say something.
So, Your Honor, I think I have it.
Listen, if you both prefer that I not say anything, I'm okay, I suppose, doing that. I just wish I hadn't said anything in the first place, that's all. But
I'm in a little bit of a bind because, go ahead.
It's fine, Your Honor. I think the language that we agreed to is based on information provided to the court by the defense. I previously informed you that Mr. Jones intended to testify in the defense case. Mr. Jones has now elected not to do so, as is his right.
How about if I just say the last sentence? Mr. Jones has elected not to testify, as is his right.
He's instructed me, he'd like me to say to the jury, I know I can't, that he's boycotting these proceedings because he feels that he's on the horns of a trilemma. If he testifies in accord with the court's orders, he'll be committing perjury. If he violates the court orders, it's criminal contempt. If he takes the fifth, he gets an adverse inference. And so from Mr. Jones's perspective, by operation of law, he's been placed in an untenable position and has chosen to boycott.
I can't address what his thought process is. I'm not going there. So I'm happy to say Mr. Jones has elected not to testify as of his right, because what I don't want is you to address it when you rest.
I think that makes the most sense because
okay. So I'm gonna I can tell them that we're gonna have a shorter day today. I'll tell them that, and then you'll finish up with whatever you have. All right, what else do we have by way of housekeeping? Anything?
In terms of jury management, Judge, you may want to send them home before I make my motion, and I without waiving, I can rest in their presence and reserve the right to make my motion thereafter.
You're agreeable to that, so we don't have to have them leave, come back in. That's perfect.
Your Honor, on the ascertainable loss issue, Attorney Pattis indicated we might have an agreement. We have some exhibits that we're planning on putting in, which we would probably use as court exhibits if we had a ruling on that issue. And I don't know that, I mean, I wasn't.
May we take 5 minutes to talk in the hall?
You certainly can.
Thank you.
Okay.
Sorry.
No problem.
Do you want to recess, or do you want to, because we're still setting up here.
I'm going to just stay on the bench because I have my own things to do here, so we'll just go off the record and stand in recess.
For reasons that will become apparent in my directed verdict motion, we can't reach an agreement on ascertainable loss. And so I believe the plaintiffs would like to have that resolved because it has an impact on the exhibits they'll offer. And we should probably do that now if we can, for economy's sake.
Okay.
Right?
Yeah.
Okay.
And so we need to do it before, we gotta do it before.
Yeah, and the issue is, does the default resolve ascertainable loss? So it's the brief that we submitted yesterday.
Right.
And Attorney Pass does not brief it.
No, I'll just, I have a brief oral argument.
Okay, all right, so we are back on the record and I will hear argument on the ascertainable loss issue. And just give me, now I'll need a minute or two. All right, so we are now on the record, so I'm just gonna ask, that we are quiet in the gallery. All right, who's up first? Doesn't matter to me. Attorney Pattis, do you want to lead? Attorney
No, I'd
Stern?
rather respond to Attorney Stern.
Okay.
Your Honor, I'll be brief, because we have already submitted a brief on this issue. So the default resolves ascertainable loss. Ascertainable loss is clearly, under the case law, an element of CUTPA. It's a liability element. It needs to be established before damages can be recovered or before equitable can be recovered. It is a very, very expansive element. The Supreme Court has actually said about ascertainable loss that it's a formless requirement which they then bound with approximate cause determination. That's the VACO case, Your Honor. So ascertainable loss is established by the default because the default resolves liability in the plaintiff's favor. Then the other thing we briefed, Your Honor, is that ascertainable loss is also effectively decided by the court's ruling in the motion to strike, which addressed almost every element of CUTPA specifically. The defendants didn't move on ascertainable loss, but they moved on proximate cause, on precision of damages, on whether CUTPA covers this count. So the court's ruling on the motion to strike already resolves this issue in our favor as well. And for those reasons, we have tried the case on the belief that ascertainable loss is resolved in the plaintiff's favor as a part of CUTPA liability. So if I may stop there, Your Honor, what we would propose to do if the court rules in our favor on this issue, though, is simply to protect the record, submit some additional affidavits that go to ascertainable loss.
And we've reached an agreement. I see Attorney Sterling sitting. I didn't want you to cut her off or anything today. And so we've reached an agreement that those affidavits can come in regardless of the ruling. And I don't want to tip my hand too much because this will reflect the directed verdict motion I made, but it's our contention that the ascertainable loss as pled in this case, given the pleadings and given the presentation, is vulnerable on appeal, on de novo review, and is susceptible to a directed verdict motion, as I will argue at the close of the plaintiff's case. So while I agree that there is a universe in which ascertainable loss might be regarded as the functional equivalent of nominal damages in the common law counts, I don't think it makes any sense in the facts in this case as pled and as argued. And so I can't agree with the plaintiffs that it's been established in a way that is invulnerable to appellate review, and for that reason I will not agree.
Are you looking to respond or no? I don't think it's necessary. So my ruling on the motion on the CUTPA count is the law of the case, but I would say even more importantly, I agree with the plaintiffs that the ascertainable loss is established by the default. All right, so that is my ruling on that. All right, so are we ready for your jury who was, again, conscientious and on time, or do you need another couple minutes?
Just
Your
one
Honor,
second on
so,
that issue, Your Honor.
Sure.
we will want to mark in the affidavits as court exhibits.
Are they gonna be e-filed by your office?
They
Because
are,
that's
I
the only
don't
thing
know.
that's gonna hold us up tomorrow for giving the jury the cases
Oh,
if these
of course,
exhibits aren't
Well,
all.
the jury doesn't need these.
No, but I'm gonna have every exhibit e-filed in the case. ID, court exhibits, jury exhibits, we've gotta stay on top of it, so I understand that,
Yes.
but I'm not gonna send it to them until Ron says to me, we're done, because he is in charge of the exhibits.
So we have, that issue which we're taking care of this morning.
Okay.
And then, where are we? Yeah, one moment.
Sure.
I'll wait so she almost said the state judge, I guess I betray my as a criminal defense lawyer.
Your Honor, sorry, we're just making sure all the house.
No, that's right, let's make sure that you're all set so that we iron this out before we bring them out, we're fine.
The other
Attorney
ironing out.
Patterson was actually looking to address the court.
Oh, I'm sorry.
On the question of the affidavits, I believe there will be 3. I've seen 2 and agreed to them. We discussed the 3rd, and there were going, and I'm assuming, and I thought we reached an agreement on that. I have not yet seen that 3rd. I've now seen the 3rd, so we have an agreement on it.
Great. Attorney Koskov?
Yes, just if I can move to a different issue before the jury gets out, which is life expectancy tables. So typically, in my experience, we've stipulated that as to what the life expectancy tables show. Now, candidly, that's usually in a single plaintiff case or 2 plaintiffs. We have 14 plaintiffs here. So what we would like to do is to have a mechanism by which the jury simply given what the tables show.
You're talking to Attorney Pattis?
We did, and according to my sources, Attorney Pattis is not in agreement to stipulate to what the tables show.
Okay.
I've never had that, but I'm not disparaging Attorney Pattis. That's his right. But typically, what counsel does is stipulate that that's what the tables show, but don't say that that's how long. That's not the same thing.
I have to say, I've never encountered it not as a stipulation, so I'm gonna have to figure this out, so.
The reason for yesterday, I was shown a list of their birth dates, everyone's, and I agreed that those could go in, because if we're gonna have a life expectancy table, we need to know how old they are, and no one testified as to their age. This morning, I saw a different exhibit which tabulated this and then had conclusions reached as to the life expectancy under the table. My view of that is, having put no evidence on as to their medical condition or health, that's they can argue that they're going to live as long as the table presumes. But I don't want to be in a position of having agreed to that, because they waived any right to have, they didn't testify as to their health. I have no idea. I mean, a table might say I'm going to live another 25 years. I could drop dead tomorrow because of the way I eat. And if I'm going to claim to live another 20-some years, I think I've got to sing for my supper, and there was no tune sung in this case, Judge, so I can't agree.
Okay.
Well, I think that's just, and I know Attorney Pattis is typically not defending a civil case, so I don't begrudge him that. But typically, I think that's handled by
Well,
the
then
court.
we need a charge on the life
Exactly.
expectancy, which talks about the vagaries and
Yeah.
such, so,
But
so I suppose I'm admitting it over objection, but I would deal with it in the standard life expectancy charge that explains exactly what
Understood.
you're talking about, Attorney
And we
Pattis.
we do have a proposed charge to that effect, along with the ages.
Why can't I just use the nice
Well,
standard charge?
No, I think that does it for the boilerplate or the foundational, but the court does need to, the court needs to plug in the numbers, because
Why don't you run past, now that I've ruled, run past with Attorney Pattis what your proposal is? It's the standard charge and you just plug the numbers in?
Yeah, except it has to be done for all the plaintiffs.
Okay,
But
so
it's
why don't you touch base on that and let me know?
right now or after?
Well, not right now.
Okay.
Like, so as soon as we can get started with the jury, the better. Unless we need more time, and then you can do it. Now, you looking for a couple more minutes, or?
Well, I think we're ready, but a couple more minutes never hurts. Whatever you
All
want
right,
to
do
do,
you want to
Judge.
do the life expectancy now? Do you have something to show Attorney Pattis?
Well,
Your Honor, this was filed on the 30th of September. This is the proposed life expectancy charge.
Well, but it doesn't address that this is an estimate independent of any, it simply says this is the normal, like the average normal expectancy, without addressing the fact that it really takes no account of the vagaries of experience.
I thought the standard charge did.
Your Honor, let me pull up the standard charge.
I'm doing it right now.
Thank you.
Here it is. Do you want to come up? I can read it. Would you like me to? If you can see the screen, it might be a little better. I'm happy to turn it. Can you see that?
Yes. May I?
You can lean over. Do you want to? Here it is.
Thank you.
Can you see, Ellen?
Yes.
You know, the standard charge addresses my concerns.
I'm just a slow reader.
Damn it. Did I miss that one?
No.
Oh, good. The old chart. The vicissitudes of life. It's a vicissitude.
We don't have a problem with that. That's fine.
But do just plug it through.
We still have to plug in the plaintiff's numbers, the different plaintiffs.
Testified as to their age and date of birth. A couple of them.
Yeah, and we have a stipulation as to their dates of birth without the date because
There wasn't much evidence of it. I mean, I suppose their mental conditions wasn't evidence, so they can consider.
It seems to me that because of the range of things that are to be considered, if the court instructs them on all these factors and they didn't produce evidence on that, that would give me some argument about why life expectancy could be discounted. And that was the thrust of my objection to the.
I understand that,
But-
I do. But
Well,
there's
this is-
no requirement that all this evidence be in. They can
Right.
take it or leave it. They may say, we didn't have enough evidence, and we're not gonna.
Well, I think it's fair to alert them to factors that they can consider, and if they've chosen not to put those in, that's on them.
I'm not sure about that. I mean,
Well, we can, why don't you, do you want me to print it out, and you can look at it, but we can tailor it to the evidence that was in, but there was definitely evidence about their mental health,
I mean,
about their occupations.
and permanent-
some of them
and permanency.
testified to their exact age, so there's enough, but I agree that,
why don't,
physical conditions.
this would
Why don't we-
imagine just, we can argue later, but just imagine like a grand collision case where somebody has a bad back and it's permanent, it goes in, and you don't have a
Nobody ever talks
cardiologist
about
come in
anything else.
or
They only have a bad
oncologist.
back.
Yeah,
The only evidence in the case is the back.
right. It's
Nobody talks about
it's similar.
cancer.
Right.
okay.
Hopefully this morning, hopefully we can.
Well, we need it
wrap
for,
up-
we need it in time for the final arguments for sure, but still, we can.
No, I mean, hopefully we can
After the
wrap up
jury.
the charge.
Okay.
You said this afternoon, I'm hoping to be done by then. I'm an
Well,
optimist.
Mr. Ferraro called me and said you plan to be here till 9:00.
I have all these words in the charge, Judge.
Do you want me to print this out or not?
Yes, please.
So the jury instructed.
You could.
Well, This is gonna, when it says complex lit fourth floor, where does that go?
That's my office.
It is?
Yes.
Fourth?
Oh, no, third floor.
Third
Go
floor,
ahead.
so that's,
Yeah. And just make sure you go down before you sit. Okay. Okay. Print on both sides. That's what it's set for. Down at the bottom there.
we don't need this now, so we'll make the jury if you don't want to, and then when you have time, yeah, there's no rush. Thank you very much. All right, so Mr. Carr is gonna get the jury and we'll get ready to go.
I'm not gonna play with you. Oh, yes. During his if you agree, then we're good.
Good morning, good morning. Good morning, everyone. On yet another rainy day. Good morning. Good morning, good morning. Please be seated. Council will stipulate that the entire panel is present.
Yes. Yes, Your Honor.
All right, please be seated. So I am so grateful you were all able to make it on time, given the very heavy traffic that we had this morning and the wet roads. And I know we ended up keeping you waiting a little bit, even though you managed to get here on time, but I can tell you, we have been very busy. We already argued a substantive motion. We went through the scheduling for the rest of the trial, and so I can actually share a little of that with you. So we are going to finish the evidence this morning, all right? And then you are going to have the rest of the day off. I can tell you that Mr. Jones has elected not to testify, as is his right. So we will finish the evidence today. We are going to work on your jury charge when you leave today, so we will continue to be putting our noses to the grindstone, and then tomorrow we will go into counsel's closing arguments. I will then charge you on what the law is, and you will begin your deliberations tomorrow. So tomorrow is going to be a busy day for you, all right? So just for your planning purposes, you will have the afternoon off, and maybe even part of the morning. We'll see how it goes. Okay? They have their notebooks, Mr. Flora? Thank you, sir. Attorney Maddie, whenever you're ready, please.
Thank you. Thank you, Your Honor. Good morning, everybody. So, Your Honor, what we're going to do this morning is just present some exhibits, some remaining exhibits. The first thing I wanted to do, Your Honor, is offer the transcripts of the deposition testimony that we played here. We decided to do that for all of the depositions, not just the ones that might have had some audio problems.
Thank you for that. And Attorney Pattis has seen them?
Yes, Attorney Pattis has seen them. And These will be Exhibit 336A, the transcript of David Jones' testimony, 354A, the transcript of Robert Jacobson's testimony, 355A, the transcript of Nico Acosta's testimony, 356A, the transcript of Joshua Owen's testimony, 363A, the transcript of Timothy Fruget's testimony, and 349A, the testimony of Michael Zimmerman.
All right.
All right.
And I just want to mention to the jury that when you begin your deliberations, you will have all the full exhibits with you at that time.
All right, just a few more housekeeping matters, Your Honor. I would also just present to the court, which I understand are going to be court exhibits, the affidavit of Ian Hockley, which is 597, the affidavit of William Aldenberg, which is 598, and the affidavit of Jennifer Hensel, which is 599.
Agreed, Judge.
I was originally may I approach Attorney Ferraro. All right. The next thing we have, Your Honor, is the actuarial table, which is identified as Plaintiff's Exhibit 800, along with Exhibit number 588, which lists the birth years of each of the plaintiffs, and we'd offer those in full.
All right, and that is admitted over objection.
Thank you, Your Honor. Okay. All right. So what I'd like to do now, Your Honor, is present some exhibits for the jury. The first is Exhibit 137. This is agreed to and is an email dated October 29th, 2014 from Nico Acosta to Robert Dew. And if we could, that hasn't been formally offered, but it's admitted, or it's agreed to, and so I'd offer it and I'd ask to publish it.
So ordered. Yes?
Agreed, Judge.
137. Okay. So this is an email from Nico at Infowars to Rob Dew, and the subject is Ebola, Sandy Hook crisis actor clips attached. You can just scroll through it. I'd also offer, Your Honor, Exhibit 221. This is agreed to, dated March 31st, 2016, a list of radio affiliates carrying the Alex Jones Show.
Agreed, Judge.
So ordered.
And we'll just scroll through this one as well. Thank you. Okay, well, we're halfway through. We'll stop. The jury will have this entire list for them during deliberations. Your Honor, also by agreement, this is, the jury has already seen, but we prepared it as an exhibit, Exhibit 278A, relating to sales totals, daily sales over one online retail platform from September 23rd, 2014 to September 29th, 2014. Let's display this. we also have Exhibit 397A. This is the cover sheet of the final state's attorney's report concerning the Sandy Hook shooting. We're offering the cover sheet with the date of the report.
And that's a full exhibit by agreement?
Yes, Your Honor.
Yes.
Your Honor, what I'd like to do now is read deposition testimony that is being offered. And I will start with Exhibit 3. $372B. This is deposition testimony of Alex Jones. B. Question. And part of the way that the message that you convey to your audience and have conveyed for the last 20 years is that there's a group of international media, financial, and political elites that are conspiring to establish a global tyrannical government to enslave and ultimately kill people. Answer, yes. What I'd like to do now is go to and Your Honor, in case I didn't do that, I offer that.
No objection.
I'd also offer 370, and we're not going to show this now, I'd also offer 372D, which is testimony of Alex Jones on the same day.
And what was that date?
April 5th, 2022, Your Honor.
Is there an objection to 372D?
It's assuming that this was part of the pretrial designation, none.
It is.
And that's also April 5th, 2022?
Yes, Your Honor. Now moving to Mr. Jones's deposition from April 6th, 2022. This is 373A, which I'm offering and I'd like to publish.
No objection, Attorney Pastor.
Assuming it's part of the designation, Judge.
Yes, it is.
All right, so ordered.
You agree with me? Okay. I noticed in your video yesterday that you posted about this deposition that you told, and which you later published on your website, that you told your audience that you are a common man, right? Answer, yes. Question, you said that Connecticut is really a bedroom community for all the richest people in New York. Answer, billionaires and people like Larry Fink and folks who have robbed the country for trillions. Yeah. Question, but you are a common man, right? Answer, yes, I am a common man. Question, where did you fly into from Texas? Answer, I forget the airport. Question, it wasn't Kennedy or LaGuardia or Bradley? Answer, no. Question, did you fly commercial? Answer, no, I flew in a private plane. $373B, Your Honor. which I had offered also from the same day of Mr. Jones's deposition. This was part of the designated testimony. Go ahead. Mr. Jones, would it be fair to say that you expect that among the millions of your listeners, many will believe that you are telling them the truth, right? Answer, yes. Question, and sometimes that truth that you tell them is pretty horrifying, correct? Answer, yes. (373) Your Honor, also from the same deposition, also designated and not offered.
So ordered.
Question, one of the reasons that you were concerned about your address becoming public is because you were concerned about the potential that people who mean you harm may be able to locate you or your family, correct? Answer, yes. Let's go to the next page, thanks. So you are fearful that people who have that personal information against you could use it to harass you or your family, correct? Answer, yes. People may have a very distorted view of who you are as a result of the way in which you've been portrayed in the media, correct? Answer, yes. If they believe that distorted view, they very well mean you harm, correct? Answer, that could happen. And it's reasonable for you to be concerned about that, both for yourself and your family, correct? Objection, answer, I think it is reasonable. Thank you. (373) Your Honor. Same deposition, also designated.
So ordered.
Question, you had millions of listeners by the time you were 24, right? Answer, yes. And you were the beginnings of a media empire, right? Answer, yes. Okay. Your Honor, what I intend to do now is play a series of videos, all but one of which were broadcast by Alex Jones during the course of this trial. And I'd like to begin with Exhibit 505, which is a clip from a broadcast of the Alex Jones Show on September 14th, 2022, the second day of trial in this case.
I am so sick of the New World Order. I am so sick of this cult of psychopaths. I am so sick of their lies and their fraud. I don't believe anything they say. And I apologize for nothing I've ever done because I did it all from a place of purity, and I've been 98% accurate.
Your Honor, I'd now like to play what have been marked as Exhibit 552A and 552B. These are clips from a video published by Alex Jones on September 23rd, 2022, titled Abomination of Justice. This will be Exhibit 552A.
Once the plaintiffs established that Infowars played this video, they dramatically introduced an emotional Robbie Parker in the courtroom. The cameras move in for the close-up, shaking with emotion by the mere presence of Alex Jones.
Now, Your Honor, from the same video, Abomination of Justice, I'd like to play Exhibit 552B.
One of the ways that you encourage your audience to give you money is in cryptocurrency donations, right?
Yes. Infowars.com/crypto.
That will end up as a clip on your show tonight. Objector advertises during cryptocurrency page.
People care about the First Amendment.
And in the cryptocurrency page, people can give you Bitcoin, yes?
Yes.
Ethereum, right?
Yes.
As well as XRP, Monero, Litecoin, USD Coin, Dogecoin, and Stellar.
This is it. Get crypto, fund Infowars. Sponsor us with Bitcoin and other cryptocurrencies.
Thanks to your donations and your support at InfoWarsStore.com. Infowars is able to broadcast free worldwide, combating the lies of the Great Reset.
Get crypto, fund Infowars.
Donate now at Infowars.com/crypto.
Your Honor, I'd now like to play Exhibit 593. This is a clip from the Alex Jones Show broadcast just last week, September 29th, 2022. This is Exhibit 593.
Attorney over there in Connecticut. What an idiot. Oh, they already rigged the jury. It's all rigged.
Now, Your Honor, I'd like to play Exhibit 595. Video published by Alex Jones as part of the Alex Jones Show on September 30th, 2022, also last week.
I mean, you go to Yahoo, you go to Google, you go to Instagram, you go to Facebook, it's Alex Jones at the top, set against dead kids, families for weeks on, never said their names, never even talked about them, all made up. And it's like, oh, my kid died, oh, and Alex Jones caused it, and it's all laughing. We're like, oh my God, Jones, you're under some attack. We better not be like you. I'm under attack because I expose these people. I'm just going to be completely honest. I totally enjoy it. Okay, so, I mean, I've reached that point of real peace where I don't just have peace with this, I enjoy it now.
Your Honor, before I get to the last video I want to play that Mr. Jones broadcast last week, I'd like to play what is already in evidence as Exhibit 23A. This is a video that the jury has already seen. It is a video that was published by Alex Jones as part of the Alex Jones Show on January 13th, 2015.
Yeah, when you're trying to decipher cloak and dagger, dirty tricks, it's pretty hard to do. It's just that when you learn that they were funded by Western funding, then you learn that it was the same Amarillo Lockheed Connection underwear bomber. Then those are big red flags that they were patsy provocateurs. The classic MO has been followed. And then, yeah, it kind of becomes a red herring, to say the whole thing was staged. Because they have staged events before. But then you learn the school had been closed and reopened, and you got video of the kids going in circles in and out of the building, and they don't call the rescue choppers for 2 hours, and then they tear the building down and seal it, and they get caught using blue screens, and a email by Bloomberg comes out in a lawsuit where he's telling his people, get ready in the next 24 hours to capitalize on the shooting. So Sandy Hook is a synthetic, completely fake, with actors.
So that was 2015. Here is Alex Jones last week on September 29th, 2022. This is Exhibit 594.
But take the Sandy Hook thing. I never really covered that. I covered what people were saying. And then later I said, okay, it happened. But now that I've seen the trials ring and how it all looks, I mean, it's definitely, the whole thing's deep state. That's all I can say. So I think the public's original instinct about it was right. I don't know what really happened there, but it is synthetic as hell.
plaintiff's arrest.
Attorney Pattis?
We'll have a motion, Judge, but we intend to produce no evidence.
All right, so the defense rests, and with that, I can send you home for the rest of the day while we get to work on a motion and the jury charge. So, Ron will collect your notebooks, but I have to say, I know that you have obediently followed the rules and that you're a conscientious jury, you're always on time and so attentive to a fault. But we are so close to the finish line now that it becomes more important than ever that you insulate yourselves from any media coverage, that you continue not to do any research, that you not have any discussions with each other or anyone else about anything that's happened in the courtroom, even though the evidence is done. That doesn't mean that even any of you can speak to each other. You will know, because I will tell you clear as a bell, when you can begin discussing anything that happened in this courtroom. And even then, you will only be able to discuss the case when you are all together and only when you are in the jury deliberating room. All right, so even then it's very strict. So with that, I'm going to thank you very much for your traveling here for a short day of evidence in the bad weather. Take your time going home because I know the roads are wet and might be a little slippery. We will start tomorrow at 10. As I said, it will be a full day. And we thank you as always for your patience and for your attention. All right, so you'll follow on out and I will stay on the bench. Whenever you're ready, Attorney Pattis.
I'm making a motion in the alternative for a directed verdict or a motion to dismiss. And I guess I'll start with the directed verdict. There are three grounds, Judge, for these motions. First is a lack of standing. Second, because of the misapplication of CUTPA, in this case, or an attempt to evoke CUTPA where CUTPA doesn't lie. Second, the failure to plead a necessary element in the complaint of ascertainable loss. And third, the presentation of the failure to present evidence that would support the verdict. And I make these motions in the face of and acknowledging the power of the default and with knowledge of the prior motion to strike, because our appellate courts have held that with respect to standing, that can be raised at any time, even in the presence of a default. That the appellate standard for review of a verdict in a CUTPA claim, even in the presence of a default, is de novo, and that suggests to me the trial court has the responsibility to evaluate purely legal claims at the close of the plaintiff's evidence. The evidence as presented in the representations of counsel thus far have been that they are seeking, with respect to the common law claims, only emotional distress. And that's all they're seeking. If you look at the manner in which the complaint was pled, Judge, the CUTPA claim is the fourth of the last of the viable counts. The negligent infliction count was withdrawn at some point. And that incorporates by reference the various pleadings that preceded it in the complaint. So, for example, in the common law complaints at paragraph 419, 432, and 446, the plaintiffs pled actual and substantial damages. And that's what they've reincorporated into the CUTPA count. Our Supreme Court is clear that emotional distress alone is insufficient to support a CUTPA claim. And I rely on Parnoff versus Aquarian Water Company at 188 Connecticut, Conaf 153, a 2019 decision, as well as DiTeresi versus Stanford Health 149 Conaf 502 2014. So the first motion is that as presented, There simply is insufficient evidence for.
Can I ask you a question, Attorney
Yes.
Pattis?
Yes.
So the CUP account incorporates the prior paragraphs which claim the emotional distress, but then the last paragraph adds the claim of damage. It's not limited to emotional distress. What say you about that?
The representations of counsel is they're seeking solely emotional distress here. There is no claim for economic damages, and thus the case as presented is going to be presented to the jury as a pure emotional distress claim, and that's insufficient as a matter of law for CUTPA. That's my claim. The ascertainable economic loss, the second claim, is as pleaded. And again, the appellate court takes a look at the pleadings to determine, even in the case of a default, whether it's adequately pled. Under Ritchie versus Main Street at 110 Con App 209, we conduct a plenary review of the pleadings to determine where they are sufficient to establish a cause of action upon default. It is our contention that they are not, because what the plaintiffs claimed was actual and emotional loss without ever claiming actual and substantial damages without ever pleading ascertainable loss. I'm not trying to impose a magic word test on the pleadings. I understand that the plaintiffs are entitled to every reasonable inference, especially in the context of a motion for a directed verdict. But it's our contention that they've abandoned their responsibility to show ascertainable economic loss. Most substantially, though, we claim that this is a novel application and, frankly, a terrifying application of CUTPA, because this is an instance in which there is no representation whatsoever that the plaintiffs were harmed in any respect by Mr. Jones's commercial activities with respect to the sale of dietary supplements. So with respect to Soto v. Bushmaster, which the plaintiffs may claim opens the door, in Soto, unscrupulous advertising was used to sell military-grade weapons to a civilian, and the courts ultimately concluded that was sufficient to support a CUTPA claim, even in the absence of a commercial relationship, because those unscrupulous ads placed into the hands of Adam Lanza a weapon that he used to slaughter people. There's nothing analogous to that in this case. Mr. Jones didn't oversell hair growth or follicle material or iodine to anyone. There's no evidence that anyone was harmed by his commercial activity. The court and the jury may conclude that Mr. Jones's speech acts were odious, and that's what defamation per se addresses. They may conclude that his speech inspired others to harass and intimidate these people, and I presume that falls under the intentional infliction of emotional distress. They may conclude that his verbal and written activities placed these plaintiffs in false light to their economic harm and detriment, but nothing in that speech or the consequences of that speech addresses what CUTPA is intended to address, or what Soto v. Bushmaster addressed, and that is whether consumers were harmed by the commercial activity affecting trade or commerce. If someone had gone out and bought a gross of these pills and thrown them at someone and hurt them, that might be an argument, assuming the ad encouraged people to do that. But what we have here is a novel attempt to use CUTPA to silence unpopular speech, and the purpose is plain. The purpose was announced in opening statements, which I realize is not evidence, but this is legal argument. The purpose of this litigation is to silence Alex Jones, and the only way they're going to be able to do that is with an enormous punitive damage award, which this court has discretion to award under CUTPA. The punitive damages will be limited in the common law claims to attorney's fees, and I'm sure they'll be significant, but they won't be significant enough to cripple Mr. Jones. So we think that CUTPA is being used for inappropriate grounds, and that the plaintiffs lack standing to bring the action because they cannot establish that they were harmed by Mr. Jones's commercial activity. As I understand the plaintiff's case, there's a strong and a weak CUTPA claim implicit within it. The strong claim is that they pay attention by way of Google Analytics and other analytics to spikes within their web traffic
Thus, when Mr. Jones speaks about Sandy Hook, it spikes. Let's talk more about it because it'll drive people to our site. The weaker claim is that by peddling fear, Mr. Jones is able to capitalize on that fear and inspire people to buy products. That might be an unscrupulous ad if a person affected by those products could come forward and say, I would never have bought it had I not been inspired by his fear. But that's not the claim here. What we have are 3 torts that will go to the jury, and my motion is not directed to those torts, Judge. I will concede that the evidence, if credited, is sufficient to warrant a judgment against Jones. But as to the CUTPA claim, there's no case, none, that supports what the plaintiffs intend to do in this case, and that is use a statute that is designed to protect consumers against unscrupulous trade and commercial practices to attack speech. And that makes this case terrifying from a free speech perspective. And we urge the court to strike this claim or to grant our motion because nothing in our law supports an application of CUTPA on the facts as pled and proven in this case.
Thank you. Attorney Sterling.
Yes, Your Honor.
And one last thing. May I submit I've got a typographically written motion that I'd like to tidy up and submit as part of this record later in the day.
How do you want me to handle it, and just wait for that before I rule?
No, I can give it to you now, but I'd like to submit it. I'd like to submit it cleaned up version.
Has plaintiff seen it yet?
I'm giving it to
No,
you now.
I have not seen it.
8 pages.
So,
Well, I wanted to wait until the close of the case, as is customary.
No, I understand, but I don't. If you're going to file it and after she's argued, how does she respond?
If she wants to take a moment to read it, she may, but it won't say anything that
I'm happy. Why don't we try to do that and see if we're able to read? Do you mind, Attorney Sterling? We can try and see if
Your Honor, if we're going to do that, what I would ask is that I have an opportunity to read it, make some notes, and then I'll respond. Given this 8 pages.
Not unreasonable. Do you have a bench copy?
I do.
Would you mind giving it to me? I sent Attorney.
May I approach?
You may. Attorney Ferraro to start working on the exhibit so that we can hopefully not have a delay tomorrow. I thank you. And is your office also going to e-file it?
Yes.
Thank you. All right. So then, why don't we hold off on the rest of the argument? Can we start to get to work on the jury charge?
We can do that, Your Honor. The only thing is so yeah, we want to defer argument for a little while on this and turn to the jury charge and then take a break.
So do you
I'll
want to take
prepare
the morning
myself
recess now? We'll pick it up at 11:30, finish the argument, and then can we get to work on the jury charge?
Yes.
Okay.
Yes. Your Honor, I understand Attorney Ferraro's not here. He raised with our team, I think yesterday, that one of the videos that we offered and played last week, it wasn't clear in the record what the number was. It's Exhibit 508. He asked me to confer with Attorney Pattis. We have. Attorney Pattis agrees that that's what it was. So I just wanted to make that clear for the record, and we can let him know later. But
Maybe you can go get a cup of coffee during our
I'll let
morning
him know.
recess and let him know that it's 5:08.
Yep, thank you.
Your
That's
cup.
all I
All
have.
right, so then why don't we plan on coming back at 11:30? We'll pick up the argument, and then we'll turn to the jury charge, okay?
Yes.
All right.
Thank you.
All rise. Courthouse stands at a 1-minute morning recess.
The video is.
You're off the record, correct?
Yes. All right, so I spoke with Ron, and the game plan is that we will get the exhibits done today by 5, so we're gonna stay and work on the exhibits, even if we're done early, whoever needs to stay to make it happen, okay?
Yep.
Okay.
Is Your Honor ready on the draft?
I am. I was able to read it. Did you have enough time to read it?
I did, Your Honor. Thank
Okay.
you. So, over 3 weeks in this trial, we have heard a description of massive damages, massive injuries to these plaintiffs, which is exactly what the allegations of the complaint foretold. And to hear that evidence described as merely emotional distress is both par for the course in this case and par for Alex Jones's approach. But it ignores the evidence, it ignores the truth, and it ignores the law. And so as I understand, the motion for directed verdict is attacking the CUTPA count alone. Our CUTPA law says that this is exactly the kind of case that comes under CUTPA. If these plaintiffs don't have the right to bring a CUTPA case against Alex Jones after everything he has done to them, then who does? And so they have CUTPA standing under Soda versus Bushmaster, but also under the plain language of the statute. Any person who suffers any ascertainable loss is entitled to bring a lawsuit. The court has already found proximate cause in the context of the default. That is the sine qua non of CUTPA standing. So that's resolved. The court has resolved ascertainable loss. These issues have been decided. In terms of the notion that this case is only about emotional distress, again, that profoundly misunderstands and misstates the evidence. The evidence is that there are 550 million impressions of lies by Alex Jones, and that is reputational injury in addition to causing emotional distress. Not only that, that's measurable in the sense of ascertainable loss, and it is catastrophic. And so to hear that minimized, again, it's just, it is understandable that what Mr. Jones would like is for these families not to have standing to hold him accountable, but it cannot be under our law. With regard to the reference to the DiTeresi and Parnoff cases, I think counsel misspoke and indicated that those are Supreme Court cases. Those are not. Those are appellate court cases, and they're pre-Soto cases. It's our position in this case that the reputational harm gives rise to the CUTPA claim as an encompassed within the CUTPA claim, and also that emotional distress damages are encompassed within the CUTPA claim under the circumstances of the case. So that to the extent that, and I don't actually think, Your Honor, that is in conflict with DiTeresi, because DiTeresi's approach on emotional distress says, well, it's not measurable. And that's the rationale for not including emotional distress as a predicate for CUTPA. Here, we have both the determination that severe emotional distress already exists as a result of intentional infliction, and also there is the measurability of the reputational harm which goes to emotional distress, although also independently damages the plaintiff's reputations. So, and Your Honor, I am putting that on the record because I want our higher courts to be aware that that is our position. Let's see. With regard to the idea that the CUPPA claim is only about statements, it's not. What it describes is a commercial course of conduct that is built on targeting and victimizing these families by lying about them. So certainly lies are in the mix, but what the court heard was not just the occasional lie. It's the use of lies to sell products, to fuel a business. That is what Mr. Watt's testimony was about. That's what the testimony about social media analytics and Google Analytics is about. There is a business plan to hurt these families and to sell things by hurting them. And that has to be remediable under CUPPA. It has to be. There were some references to the complaint, Your Honor. The CUPPA count is pleaded last, and it incorporates all the prior allegations. And there were some representations by counsel that my clients are only claiming emotional distress. That is inaccurate. My clients are claiming reputational damages and emotional distress. And, excuse me?
Sorry.
Yes, an invasion of privacy. So I just don't understand the source of those representations. The reputational harm includes all the evidence that the court has heard, which has included evidence of economic loss. We're not seeking to recover those damages, but that is all in the case. And certainly evidence of ascertainable loss has come in repeatedly in the case, even though it's already established by the default. One of the grounds for the motion, Your Honor, was that the complaint fails to state a claim for ascertainable loss. We've already covered that this morning, so I won't address that. So I think where I conclude, Your Honor, is there is absolutely a CUPPA claim that needs to be presented to the jury and will be also for decision by the court. And the motion for directed verdict must be denied.
Attorney Pattis?
I guess I should get used to even polite ad hominem attacks that are the course in this case. I won't respond in kind other than to say that counsel's argument is long in emotion, short on analysis, facts, and vacant as to law. There is no CUPPA case that says a person who engages in speech, even in extreme speech, can be held liable under CUPPA. We don't contest at the directed verdict stage defamation. We don't contest intentional infliction. We don't contest breach of privacy. Those cases will go to the jury. We're not arguing that it's statements alone. I conceded in my opening statements, as I do now, that under the default law, the harassment and intimidation by unnamed and unknown persons are attributable to Alex. That's fine. I get that. But what CUPPA sounds at it's not enough to come in here and say it can, it must, it has to be. The argument has to conform to the requirements of law, and there is nothing in Soto v. Bushmaster that says that if a person engages in extreme comments and relies on the sale of products to produce that platform, there's nothing that says absent the plaintiffs being affected by those products that CUPPA is applicable. The reason we have a broad medley of torts in this country is to permit people choices of remedies so that they can recover for the harm they've experienced. The harm that these folks have experienced in terms of defamation, intentional infliction, and breach of privacy is compensable, and they can get what the jury will award them. What they can't do is transform cutaway into an attack on speech.
All right, so the lack of standing raises subject matter jurisdiction, and I must rule on that now. So the motion to dismiss on the standing issue is denied. The motion as it relates to ascertainable loss is also denied, as I ruled on that earlier, and I will reserve decision on the remaining issue. Ron, can you give the council copies of the life expectancy table that I was able to print out? Thank you. All right, so can we
Your Honor,
turn?
may I inquire on one issue? So the court is reserving decision on the
I just
whether.
routinely reserve decisions on all motions for directed verdict, and I would have entirely reserved here and just dealt with it later. But because it raises standing, which is subject matter jurisdiction, I need to rule on that. The ascertainable loss I already ruled on, so I'm denying the motion as it relates to that, and I'm kicking the can as I always do on the rest of the directed verdict because that's.
So, Your Honor, in that event, I think maybe we'd like to submit a brief on the non-standing issues.
Sure, I don't see why not.
Okay, thank you.
Okay.
I should say maybe we may want to.
All right, so we're ready to go on the charge?
Yes.
Yes. I just need 1 second to clear away these papers. Oh, yeah, Attorney Paskoff's going to start with life expectancy, if that's all right, Your Honor.
Well, I wanted you to talk to Attorney Pattis about it first.
Okay.
If you don't
So we'll
mind.
do that at the break, Judge, or do you want to just do that right now? We got a
Whatever
lot
you
of
want, it doesn't
housekeeping.
matter to me.
Maybe you guys want to do, well, it's up to you.
I think I have a short one. While Attorney Sterling is getting organized here, I want to talk about how long we're going to have for closing. I know Attorney Pattis has requested an hour. We've requested 2, which would be inclusive of summation and rebuttal, 15 plaintiffs, 4 weeks of trial. I understand that Attorney Pattis wouldn't consent to that, and so we just wanted to have some clarity from the court on what we'd be allowed to do.
Attorney Pattis, do you want to respond?
Yes, I think in opening, the position was better a divorced concision, although it's been a 12-day trial, maybe we've had 12 days for partial evidence, and 15 plaintiffs, the plaintiffs are all similarly situated, and there's nothing that distinguishes them one from another. And my view, Mr. Richmond and Ms. Hensel may have claims that are different in kind, but everyone else more or less looks the same. And I don't see the need for more than an hour, and so I would request the hour.
I disagree, so both sides can have 2 hours. Okay. Do you want to?
Well, I didn't want to get us off track.
Why don't you and Attorney Pattis?
I could look at this, Judge. Actually, excuse me, sorry, Judge.
No, that's right. Do you want to do it together now, or do you want to wait?
Why don't I look at there's some things I just need to correct, because this is for a case where there is a liability issue, so let me just make some corrections while you guys are.
And you'll.
And I'll show it to Attorney Pattis.
Okay. Okay, give me 1 moment to get situated. One thing that we left off on yesterday, and I've got a list here that I'd like to start crossing off, was the plaintiffs were considering proposing new language about Alex Jones and free speech systems.
Yes, Your Honor, good news. In the new charge that Your Honor has a copy of, we did propose new language, and that was acceptable to the defendants.
What page is that on?
That is on page 7 in red.
May I have a moment, Judge?
Please.
There is an agreement on that language, Judge.
Okay, so I can cross that off the
Yes.
list.
Your Honor, on that charge, though, I just think that we should look at the top part of the charge then and make sure that it's not confusing in relation to that instruction.
I don't understand what Attorney Sterling is referring to as top part of the charge.
So the top part of the charge, corporation or other entity as party, which is on page 6. Your Honor, I think that's quite confusing given the instruction that Mr. Jones and Free Speech Systems are each legally responsible for the other's conduct.
Well, except that one of the parties nonetheless is an LLC, so there's nothing wrong with saying you must treat all parties in an equal and unbiased fashion, right?
No, I think that's fine.
So why don't we take out the sentence under corporation or other entity as party? Take out the verbiage, rather you must assess the claims and defenses of all parties without regard to their, and just put in you must treat all parties in an equal and unbiased fashion. So that would be, you have heard that one of the parties in this lawsuit is the defendant, Free Speech Systems LLC, which is an entity created by the law. All parties are equal before the law. The mere fact that one of the parties is, I don't know if we want to say one of the defendants, but one of the parties is a natural person and one is a creation of the law should not play any part in your deliberations. You must treat all parties in an equal and unbiased fashion. That's not objectionable. That's neutral.
I take no position on this. I think it's fine as it is, and the court's suggestion is fine. I don't think there's anything confusing about it.
Your Honor, I think that's a significant improvement. I appreciate it.
All right, so
Thank you.
you'll delete, rather you must assess the claims and defenses of all parties without regard to their, and insert you must.
You must.
Okay.
Got it.
What about the implicit bias charge?
I can't agree with it. I can't agree to it, Judge. I mean, the basis is that somehow using cool reflects some sort of bias or is a microaggression against some unnamed group. I mean, the language is all we have left. And to start making claims like that about language, to talk about cool and dispassionate, I don't want to go down that rabbit.
We're urged to use the implicit bias charge in all our cases, civil, criminal.
But this arose with respect to the claim that cool was somehow culturally.
But Attorney Sterling wasn't even sure she was going to want it anyway, so before you start arguing against it, let's see what her position was.
So my position, Your Honor, is as I am delinquent, I need an opportunity to look at it.
And this
I
is
will
the
do
time.
that. Okay, then we're not claiming it.
There we go. Okay, we're moving along. All right, where are we next? What's the next issue? Should I go back to what I had to do, my homework from yesterday, or do you?
Yes, that would be most helpful.
Okay. So correct me if I'm wrong. The first thing that I was supposed to look at was on page, well, I don't know if there's a new page number now, so let me look. Under causes of action?
Yes, that's what I have, Your Honor, the nominal damages.
Right, and I think that I have, I'm going to delete the only if the plaintiffs can prove damages are they entitled to more than a nominal sum, because it's covered plenty of times in other places.
I'm not sure that exact language is covered anywhere. I think it's important for this jury to know that that's the starting point.
Well, so let me see, just bear with me. So, under damages compensatory, we have, in order to recover more than nominal damages, the plaintiffs have the burden of proving their entitlement to recover damages by a fair preponderance of the evidence. Then we also have nominal damages. Let me see where it is. I marked a couple other places, but just bear with me. Paid under damages for libel and slander per se. So it is going to be what it is going to be, so.
Yeah, I understand, Judge. I just wanted to note my objection.
Yep. All right, so then I have under defamation, is that where we?
That would be page 17, Judge?
Well,
Yes.
I'm looking at yesterday's document, honestly, because that's where I made all my notes. So I thought there was something for me to do under defamation.
No, we resolved that yesterday, Your Honor.
Okay.
Hey, that's what I have, Judge, that we had.
Okay. Then proximate cause?
That was a place where the court was going to make a decision.
I did. And just bear with me for 1 second.
May I speak to Attorney Maddy for a moment?
Please.
It's my fault. I wish I had somebody hear that.
All right, I had no problem with any of the plaintiff's proposed changes under proximate cause. I thought it was helpful language, actually.
Okay, so for my work as a scrivener, Your Honor, I will
Which I'm
accept
leaving to
those
you.
changes.
And I'll just recite my objection on the grounds that it comes perilously close to transforming proximate cause into but-for causation.
I
And I
understand.
understand you've ruled, Judge.
Okay, so the next area I believe I have is standard of proof damages.
Yes, Your Honor, the continuing objection on our part as to nominal.
All right, so just bear with me. So I am going to delete the first sentence then I'm going to change it. The sentence that says because, the first two sentences, I'm going to delete. And what I intend on saying is the following. Although the court has already determined that the defendants are liable to the plaintiffs, I must still instruct you as to the burden of proof in a civil case such as this. And then go on to, you may have heard in criminal cases that proof must be beyond a reasonable doubt. I can't see how that's objectionable. They need to know what the burden of proof is.
Are you deleting in order for you to award more than nominal damages?
Yes.
I object. That's
Okay.
second deletion of that concept.
All right, well, this is the standard of proof. Anything from the plaintiff?
Your Honor, if could the court just recite that language again? Just want to make sure I have it.
Although the court has already determined that the defendants are liable to the plaintiffs, I must still instruct you as to the burden of proof in a civil case such as this, period. And then it goes on, you may have heard in criminal cases.
Thank you.
All right, the next thing I had is under, and if I'm skipping something, you have to let me know. Damages compensatory?
Yes.
Okay.
And there we have the nominal issue again.
So let me address the list of, I think we all agreed that wrongdoing instead of negligence already, right?
Correct.
Yes.
And injury, we're gonna use harm.
Correct.
Yes.
Okay.
And Your Honor, I intended to make those changes globally. Oop, I missed one.
All right. So I think we've talked about the whole issue of nominal damages, whether they're appropriate, given some of the claims. And I've looked at the case law as best as I can, and I think what the plaintiffs are arguing is that in a defamation per se case, nominal damages are precluded. That's what I hear. Am I understanding that right? And that there's some kind of, I don't know, default or assumption.
No, Your Honor, the first argument actually goes to the emotional distress damages.
It's the same sort of argument though, isn't it?
Well, I think it's actually even clearer and stronger as to emotional distress, because the court is charging, the court heard my argument yesterday.
I did.
And so, it's inconsistent to say that there's severe emotional distress. The court understands the argument.
I do, and I'm gonna not rule in your favor on that. I don't think that that nominal damages are precluded on these, in this situation. So what do we need to do here under damages compensatory?
So Your Honor, we'll stand on our objection there, of course?
Yes, absolutely.
I'm not sure there's anything more to.
I'm just triple checking to make sure. Are we otherwise set on this section?
I have red lines, and I agree with the red lines. I don't recall talking about those yesterday. Eliminating pain and suffering, for example.
Yes, we did agree to that.
Yes, we did. Your Honor, I'm sorry. Is the court just accepting that in order to recover more than nominal damages, the plaintiffs have the burden? Was the court proposing a revision there?
Give me one moment. I'm not sure. So we can try to work on different language to make sure we're stating it right. So so what about this language? The plaintiff's burden. This is, well, we're under damages compensatory, and I think plaintiffs had an issue, if I'm not getting it wrong, second paragraph that says in order to recover more than nominal damages, the plaintiffs have the burden of proving their entitlement to recover damages by a fair preponderance of the evidence. Am I on the right sentence?
Yes, Your Honor.
All right, so if I lift the language exactly from an appellate court, from the Murray versus Taylor case, I'll read a sentence from it and tell me if we can make this more accurate or more palatable. The liability of a defaulted defendant is established, and the plaintiff's burden at a hearing in damages is limited to proving that the amount of damages or harm, or whatever you want to call it, the amount of damages claimed is derived from the injuries or harm suffered and is properly supported by the evidence. So you want me to read it again?
Yes, thank you.
All right. The liability of a defaulted defendant is established, and the plaintiff's burden at a hearing in damages is limited to proving that the amount of damages claimed is derived from the injuries suffered and is properly supported by the evidence. That's the language Murray versus Taylor lifted from Ratner versus Willamette. So,
And Your Honor, the idea would be to take out that.
well, I think it's probably, I think we're safer if we lift the language and quote it directly.
I'm not seeing what we're lifting. I'm not following.
I think the issue of what do the plaintiffs
No, I
need.
mean, I'm not seeing
Oh.
it I'm on.
Under damages compensatory, there's the first paragraph that starts the rule of damages as follows, and then, oh, I guess it is still the first paragraph, I'm sorry.
That's what threw me. I don't see.
I'm sorry, yep, it's the first paragraph. That's a long paragraph. Maybe around 5 sentences down, and it starts with an order to recover more than nominal damages.
No, I think if you want to add the Murray language, fine, but I believe that this is the third instance where we're just diluting the import of the nominal damage instruction. Yeah, so I wouldn't object to adding Murray after that sentence.
Well, it is, you're right, Attorney Pettis, it does not use the word nominal damages, and I think this would be the appropriate place to put it in, so I agree with you on that. So let me look at it and.
Your Honor, if I may, this had also implicated defamation per se, and the court had a question there.
I'm sorry?
Sure. So with regard to the nominal damages issue, the court began with a question about our position on defamation per se. And I'll repeat that position from yesterday, which is that nominal damages in that instance could only be appropriate in the way that's described by the charge, which is that the plaintiff gets set back by all of these aspects of the evidence like that.
I understand your position, I just don't.
Thank you for hearing me,
disagree
Judge.
with it, though. Yeah, okay. So,
Your Honor, may I be excused for a few minutes?
certainly. So how about this language? In order to recover more than nominal damages, the plaintiffs have the burden of proving that the amount of damages claimed is derived from the harm suffered and is properly supported by the evidence.
No objection.
I mean, that is, I mean, we can't get any more accurate under the law.
So I apologize, Your Honor, but would you mind giving
Yeah, no
it to
problem.
me one more time
Sure,
so I
sure.
can see what's
I'm so
in-
happy that you're going to be doing it that I'll repeat it 10 times for you if you
Well,
want.
I hope so then we really need to make sure that I've
Yeah.
got it right. So if we started, our laws impose certain rules to govern the award of damages in any case where liability is proven.
In order to recover more than nominal damages, the plaintiffs have the burden of proving that the amount of damages claimed is derived from the, we're going to say harm instead of injuries, right? Harm suffered and is properly supported by the evidence. Because that language, the amount of damages claimed is derived from the injuries suffered and is properly supported by the evidence is long-established case law.
Could we include is derived from the harm suffered as I have described it to you and is properly supported by the evidence?
I don't think so. I mean, unless you're agreeable to that, Attorney Pattis. I'll do it.
I thought the charge as stated was fine. I thought that the next one was fine. It seems like, no, I don't agree because I think the court has indicated what it wants to do. And
Yeah, I think it's
arguing
clear
the margins.
and it's an accurate recitation of the law. So I think that's where we'll leave it.
Okay, we'll stand on our
understand.
exception, Your Honor.
Okay. So I think, and again, you have to tell me if I missed something.
In
We are-
damages for
Yes.
invasion of privacy
Oh.
and emotional distress, I made a mistake, Judge. I did not take out the non-testifying plaintiff, so I'll take that out in the next
Okay.
round.
So my next item, I think, was under damages for libel and slander per se.
Correct.
And I think the only issue that was left was near the end, if I'm not mistaken, and tell me if I'm wrong, near the end that says, if on the other hand you find that the defamatory material is of significant character, that language?
Yes.
All right. Where did that language, very substantial damages, come from? That was interesting.
Yeah.
I was very interested by that. I couldn't find it in any case law anywhere, but
I think the Koskoff brief bank did.
Well, in the case of Costco v. Sterling.
I'm going to attribute that to Attorney Koskoff, Your Honor.
That was the very, but not the substantial.
all right. So obviously,
No,
the very-
actually, the substantial is in the case law.
Oh, I know that, but I
yes.
never.
But
I'm
the
familiar
very,
with that.
the very is.
The very.
Am I very?
It doesn't exist.
You know, he's going to blame me for that.
Give you A for effort, though. So, Attorney Pattis, what is your taking out the very? What is your issue there? Because I don't see an issue, but I could be missing an issue.
I didn't see the need to depart from the standard charge. It struck me that this was reflecting the argument that wanted to be made at closing, which is fine, but I didn't see any deficiency in the standard charge.
All right. Okay, so I actually, I try to look at it from the perspective of the juror, giving them guidance. I liked it. I thought it actually clarified things, so I will include it.
You note our objection.
Absolutely. Okay, so I think that gets us up to new ground, correct? No?
There's a tail end of that charge, Your Honor. So
What am I looking at?
on page, well, let's see. After the new language about you may award substantial damages,
Okay.
the language we just added, there's a sentence, nominal damages are also awarded when they are the only damages claimed and the action is brought for the purpose of vindicating the plaintiff's character by a jury verdict that establishes the defamatory material was false. That just doesn't fit this case.
No, it does not.
It doesn't already that.
Okay, so that's.
So that comes out. And then the summary language,
I thought it was confusing.
I think it is because we're not claiming specials.
So can you and Attorney Pattis maybe put your heads together if you want summary language? Because I do,
Your Honor, I don't think we need it at all. I'll certainly discuss with Attorney Pattis if he feels that
If
we
we want to
do.
leave in at a minimum, each plaintiff should receive a small amount of at least $1. I'll agree to eliminate just two preceding sentences if that sentence remains.
No, we can't agree to that.
Then you probably should decide, Judge, because I'd give up. This is,
I actually think, Your Honor, I think we should keep the language about you may award punitive damages as a matter of discretion. I think that needs to be in there.
all right, so I thought the summary was just a little confusing, but do we want to put some less confusing summary in? I'm okay with leaving that you may award punitive damages as a matter of discretion, and at a minimum, each plaintiff should receive a small amount of nominal
you
damages.
can eliminate the summary sentence in my view, Judge.
We don't need it?
Correct.
Okay, but we do have an issue with
I understand.
should receive a small amount of nominal damages of at least $1.
I'm wed to that exact language, but I think that we need to include the nominal damages somewhere here.
I think this states it precisely. At a
Well, we
minimum.
do have earlier in the charge, nominal damages of $1 may be awarded. Then we talk about substantial damage. So we do earlier in the charge talk about nominal damages.
You know, Your Honor, I'm just looking back up
A lot.
that this is the
Well, we've
nominal.
eliminated several, so don't say a lot, Jeff.
Well, look at the earlier part of the charge, we talk about nominal
But we
damages.
revisit compensatory damages because there are special considerations with respect to defamation. And if we're going to revisit compensatory damages, I think we need to revisit the anchor, and the anchor is nominal damages.
No, I mean, Your Honor, if it just ended with you may award punitive damages as a matter of discretion, that would be.
That would be great.
Yeah, wouldn't it be? Maybe,
Well,
maybe say. Maybe
and it wouldn't be long-winded.
Made as should, you know.
Well, but can I, we say, so, just bear with me, at the beginning of the charge, right, damages for libel and slander per se, just bear with me. So we talk about, we have the sentence, if you find the plaintiff has said blah, 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 he or she is entitled to at least nominal damages. Then we say nominal damages may be awarded because you find the defamatory material is insignificant, blah, blah, blah. Then we also say nominal damages are also awarded when they are the only damages claim.
But we took that out.
We took that out.
Oh, am I looking at the wrong version?
No, we just
I
discussed.
think I have the same page twice.
Well, it is confusing here. So
I'm going to leave the last two sentences in for now, and as soon as you can get me a clean copy and I can eyeball it, and I'll leave the door open to address it again on both those sentences.
Thank you.
Okay? There's so many strikeouts now, and I'm working off a different version. I don't want to say it 8 times, but I sure don't want to not miss it, and not say it. All right, so
Understood.
now we're up to cutba, correct?
Yes.
Okay, and that's where we left off, no?
I don't recall.
I don't know that we,
I think you've decided the ascertainable economic loss
yes,
thing.
but I mean, we haven't
Right.
talked about the charge
We haven't.
specifically, so tell me what we need to do under, what's the first thing I need to decide?
Well, we had asked that the court extend its charge to charge on ascertainable loss given the defendant's argument, and so I would ask that the court do that. So that is, we're asking that the court charge on it as an element of liability, that it's been found.
So what is
I don't think it's necessary.
No, I don't think it's necessary either at this point. The court's ruled, I've got it preserved.
Okay.
All right.
Yeah, that's fine.
Okay, so is there anything I have to address under cutba?
Your Honor, just for the record, I'm not thinking that because we're not asking, at least in my conception of the way the verdict form would go, and this could be affected by the verdict form. In our approach, we would not be asking for the jury to allocate specific cutba damages. We would simply ask them to allocate emotional distress and reputational damages. So what I want to make clear for the record here, and I understand the defendants dispute this, is that in our view, all of those damages are cutba damages. Reputational harm and emotional distress. I don't think that has to be addressed in the charge here. I just want to make it clear on the record.
All right, so what is the next thing I need to address in the charge? Tell me what page. I'm now working off the same version you're working off of.
Let's see. I think that would bring us to to suggested amount of damages.
Okay.
And I think we did talk about this briefly. You know, I prefer the standard charge. I don't know what.
I do too, so I don't see any reason to deviate from it.
Your Honor, we just feel that it's important that the jury know that all counsel can make those
Sure.
arguments,
I like
and
the
that's the
charge.
basis for
I don't think it's necessary.
Then, Your Honor, on the punitive damages charge, if you
What
look
page
at
are we on?
the plaintiff's.
35.
Sorry.
35?
Yes, ma'am.
35, yeah, is where it begins. I'm just not saying page numbers because I'm not sure which version everyone is looking at.
Okay.
If the court goes on to the plaintiff's proposed version, we had added the definition of willful, wanton, and malicious.
Well, that we needed to do. So
Yes, that needed
I
to be
agree.
done.
That was
We
not,
agreed to that.
And the defendants agreed, so we're done with that.
I had one objection, Judge, and that is because of the way this case lies, that is 3 common law counts and a statutory count, and the prospect for unlimited punitive damages in the statutory count, I object to the language that talking about punitive damages being limited to attorney's fees and expenses, because that will, I expect the plaintiffs to argue that the Jones conduct has caused such long-standing and ongoing harm that into the future these folks will need compensation, and thus we need an enormous sum of money. I'll argue otherwise, but I think telling the jury that punitive damages are limited leads them to believe that this is the only bite at the apple that any fact finder will get as to Jones, and might incline them to pack more damages into the compensatory than are warranted. And thus, I think they will be told that punitive damages are decided by the court, but it's misleading to tell them that punitive damages are limited to attorney's fees and expenses in this case, because they're not. And so I would recommend plaintiffs seek an award of punitive damages, and then punitive damages may be awarded if you find. And I would request that the limitation of the language saying limited to attorney's fees and expenses be excluded. I understand it's part of the standard charge, but the standard charge contemplates this count perhaps being charged in isolation. Given the law of the case as a whole, I think this misleads the jury about what they're going to be doing tomorrow or the next day.
First of all, it is the standard charge. Second of all, the jury should be entitled to know what the truth is, and what their award here will mean.
I agree.
Well, are they going to be told then that if juries are entitled to know what the truth is, are they going to be told the court will have the ability to assess punitive damages in an amount it finds in its discretion? Because that's the truth and the whole truth.
Well, Your Honor, what I meant was, and Attorney Pattis.
I mean the whole truth.
No, what I meant was the truth about the work that they are doing. No, they are being charged to do this. They're entitled to know what it is, and they also, I mean, it is the standard charge. I think one of the reasons why it's the standard charge, and Attorney Pattis's argument, if it were viable, would be in so many cases. I mean, it would be in any case where there's a cup account, and any case where there is an intentional tort. So I don't think that.
What would be the harm in that? What would be the harm in letting the jury know the truth? I mean, we're here on a default where with extreme limitations as a result of sanctions on what could be told. My client has frankly elected not to testify because he thinks that telling the truth exposes him to harm here.
So are you suggesting, Attorney Pattis, that the language after limited to attorney's fees and expenses, that the words at the court's discretion be included?
I'm suggesting they be eliminated, or in the alternative, the jury be informed that the court may award punitive damages in an untethered amount or in its own discretion under the cut account in addition. Because what I'm concerned about is the jury thinking this is the only bite at the apple that a fact finder is going to get. And therefore, we better load it up where we can in the soft money that isn't future economic harm.
Your Honor, the court pointed out how important it is to charge fair, just, and reasonable over and over again, and it has.
Right.
So
I agree. I'm going to leave that language in. I understand Attorney Pattis will take an exception. All right, next.
I think that's it.
That brings us to the end of this charge,
All
Your
right,
Honor.
then we have your filings.
We do.
And have you had any discussions with each other about them?
Briefly,
or no?
we have.
Very briefly, yes. So,
just give me one moment, please.
And at some point, Judge, I need to take an exception to a charge not given. I don't know when you want me to do that.
A charge that was requested and not
Yes,
given?
yes, Judge.
I suppose after I charge, right?
I can't remember. It's been a long time since I've tried a civil case. I usually just do criminal.
I'm sorry.
I usually take the exceptions after the charge, and then, if I missed a word or something, which I'm old.
Well, no, I mean, it's the substantive. It's the jury nullification charge.
Well, I think you take that after the charge is given. All right, so let me pull up the case and tell me which one, but do you have agreements on any of them or no?
I don't think so.
Okay, so tell me which one you'd like to do first, please.
I think we could take them in order. This is docket number 1001, Your Honor.
So Attorney Pettis, I don't yet see your office having filed your motion for directed verdict. Just please make sure that they get it in today so I don't worry.
Yes.
Okay, thank you. 101.
I'll take care of that at the lunch break, Judge.
Yep, 1001, correct?
1001.
I have to get in, so. So we're taking up number 1 first.
Yes.
Defendants are responsible for worse damages due to plaintiff's vulnerability as grieving parents. So just 1 second, if you don't mind. This is like the eggshell plaintiff? Yeah.
Yes, it is. What we try to do is adapt eggshell plaintiff to this circumstance.
Is there an eggshell plaintiff standard charge?
There is. It's 3.4-1. And it's a paragraph in 3.4-1, which is damages general.
All right, so just give me 1 second to get to 3.4. Just trying to find it. It's a long charge. Do you remember where it is in that in the standard charge? Oh, I see. It's the last.
Yeah. I can get there, Judge. Give me 1 moment, and I'll pull up the standard as well.
Do you want me to just read the last 2 paragraphs? Attorney Pattis?
Yeah, I object on the following grounds. The plaintiffs, what the court is unaware of, the discovery was done. The plaintiffs, in some cases, had extensive counseling and psychological issues
some even predating the loss of their children. The plaintiffs elected to produce none of that, to offer no testimony about their psychological state. And we, to avoid enraging the jury and given the court's rulings on causation, didn't address it either. We even reached certain accommodations as to one witness to cover this claim where the plaintiffs agreed to ask a question so that we wouldn't be in the awkward position of putting a person on the spot. I think they're free to argue that, but I think given the evidence that they produced or didn't produce, they're trying to have their cake and eat it too. There was significant damage of alternative sources of harm and vulnerability in these plaintiffs that could have been produced. It wasn't, and I don't think they're entitled to the charge having made the election not to produce the evidence where it could have been challenged.
Your Honor, our client's medical records were produced extensively to Attorney Pattis.
And we're not claiming that they weren't.
Well,
To the contrary.
but the thing is, so Attorney Pattis had the ability to cross-examine on them if he chose. Our clients testified at length about their emotional state in relation to the deaths of their loved ones at Sandy Hook.
Well, the nice thing about the eggshell plaintiff charge is that it makes clear that you can't compensate plaintiffs for pre-existing. I mean, you could word it in a way to make it.
Our claim, Judge, is that notwithstanding the fact that many of these folks sought extensive psychological care, the plaintiffs chose not to put any of that evidence on, and now they seek the benefit of not having.
Yeah, I don't agree with that. I mean, there was extensive evidence about their emotional and mental health
but not
after
about treatment sought and other sources of harm. In fact, the court's causation ruling made it quite clear that I was limited in what I could do.
But there was abundance of evidence. There was some evidence about counseling.
There was, Your Honor.
Yes.
12 visits to an AEP person.
No, and then I could look through my notes. One of the recent witnesses also.
There was.
There was one witness that talked about counseling that they went to with their spouse, and then I thought there was another witness, but it's not even.
So, for instance, here's the Soto girls, Bill Aldenberg. There's extensive evidence, if it turned on counseling, which it doesn't.
Just give me 1 second, please.
This is the standard.
Well, this is a one-way street, the way that it's drafted. It doesn't make clear that they can't be compensated for their original emotional distress that predated the wrongful conduct.
Oh, okay. Your Honor, so I'm looking at the standard here. So this is fine, right? And then
I mean, the standard says you may not compensate the plaintiff for it says pre-existing injury itself.
right. So Your Honor, may we have a moment, because there's a lot of whispering in my ear. It makes it hard for me to concentrate. This is the language in the standard. So, Your Honor, we think the standard would substitute appropriately here. The only thing is we'd have We just want to adjust it the way we have been.
Just the first paragraph.
One moment.
So for example, you may not compensate the plaintiffs for
The loss of the suicide of Mr. Richmond, the suffering of their children, you know, you go on and on. The loss of their, you know, the loss of their, the loss of the decedents. I mean, I think that they're free to argue that. We're both free to argue. I just don't think. I think it's a difficult thicket to wade into here.
So the issue we're having, Judge, is the proximate cause language in here, and the way that it is, how we resolve that when causation is already addressed by the default.
Just give me 1 second, please.
If I could suggest that the charges were due in this case September 19th. This is a supplemental charge, untimely filed, foreseeable from the beginning of the case, and it's now beginning to take on a life of its own, and we're revisiting issues we've already addressed multiple times.
I would say, Your Honor, if I may, sorry. We believe, I think that the truth here is that this issue has been resolved by the default, much the same as it's a proximate cause issue. I agree with Mr. Pattis's first comment on this, actually. I didn't realize the proximate cause was in here. This issue was resolved by the default. These plaintiff's damages that they presented in court are all related to the misconduct by the default of Mr. Jones. And so what this is an attempt, Mr. Pattis wants to attempt to bring in an alternate cause.
No, I didn't suggest
excuse me, Mr. Pattis. Mr. Pattis is trying to attempt to bring in an alternate cause of the plaintiff's emotional distress, which is foreclosed in this case, because that's an alternate cause of damages. That has already been decided. So, in other words, it would be improper for him to argue that the emotional distress that they're suffering isn't related to all of the evidence that we put on what the Jones has done through his conduct, but is related to the other things in their lives, and that's just not allowed. That ought not to be allowed on the default. That's bringing back in causation. Now, granted, the emotional distress has to start after Mr. Jones gets into the picture. Everybody agrees with that. So in other words, it would be equally, wrong to say that he's responsible for the emotional distress before he gets into the picture, which was about 3 hours after the shooting.
Because this is verging on incoherence. I'm objecting to their request to charge, and they're attributing motives to me for my objection to their request to charge. I understand what the law of the case is here. I don't think the charge is necessary. I think it's an effort to relitigate issues that are raised judicata, not just with respect to the law of the case, but in the charge as a whole.
What about language along the lines, I think this actually helps both sides and makes it clear. Something along the lines of, you may not compensate the plaintiffs for emotional distress, whatever you want to call it, suffered prior to the defendant's wrongful acts. However, if you find that a plaintiff was more susceptible to harm, the defendants are responsible for damages to an especially sensitive plaintiff. Something along those lines, so that we're making clear to them, you can't compensate the plaintiffs for their emotional distress related to the shooting, but
I think it's parsing a line that doesn't need to be parsed. I don't think the charge is necessary.
well, I know that you've made that clear, but I
object to the proposed
I think the court's proposal covers it appropriately.
I'll give it some thought.
And Your Honor, I didn't get exactly what the court said there.
It's not perfect. It's
understood. I
mean,
just wanted to.
Listen, the truth of the matter is that they can't compensate the plaintiffs for their unrelated emotional distress that they suffered as a result of losing their children prior to the defendant's wrongful acts, or their emotional distress related to losing their children. That is not. This is where it gets a little tricky.
And I would just say that's the. We're getting back to the raison d'etre of the eggshell skull in the first place. That at some point these things join, and they join 3 hours after.
I hear you, but I just decided I'm not going to give the charge. You're going to deal with it in argument, and if there is something occurs during the argument that's not copacetic, that's not accurate under the law, then I'll reconsider that, because there's something to be said for making it clear to them. All right, so if somebody crosses the line or it needs clarification, then I'm going to have to go there.
Can I speak to Attorney Koskoff for a moment?
Sure.
Thank you, Judge.
You're welcome. So number 2, I did say earlier that I was going to address this, and I do think this is appropriate. I don't know that it needs to be so long.
Can you remind me what number 2 is?
About all the evidence that was elicited that that Mr. Jones, I didn't say their names, or I didn't say a name. That seemed to be a little confusing, I think. So I think that, and I did say earlier that I would address it in the final charge, but this is way too long.
Judge, we would object to it at all, because as pled, the plaintiffs never referred to him as the sole cause, but as the primary cause. And that leaves open some brief wiggle room, and we believe that supplemental charge charges out that wiggle room and makes it appear as though Mr. Jones started it all for the world as a whole. And that's just not even what was pled. But that's how the case ended up being tried.
So I understand that, and your exception will be noted, but I like just the one sentence: the defendants are liable to the plaintiffs in this case, and it does not matter whether or not he singled them out by their individual names. And that's all that.
I think that's correct, as given the law of the case.
So that is, say again?
Without agreeing with the law of the case, I think that's consistent with the law of the case.
So I like that one sentence somewhere where would you propose that it go?
In the thank you note to the juror after they've returned the verdict. I don't take a position on that.
Attorney Sterling, where do you
Maybe
see-
in the evidence section, where you tell them about their duty to find the evidence and follow the law.
It seems to me it should go in the defamation charge, not the defamation damages charge,
Right,
but
so
the defamation charge.
Give us the proposal now so that we can see if Attorney Pattis can live with it. Why don't you just make it the second sentence?
The second sentence in the defamation charge?
Yeah, the court has determined that the defendants are liable for defamation. The defendants are liable for defamation, and it does not matter to their liability whether they were singled out by their individual names.
That's elegant. We agree.
Okay. I mean, that makes sense.
That's fine, Judge. Thank you.
Okay, next.
Okay.
Just bear with me. I don't see this.
I don't know which one you're on.
First Amendment, Second Amendment, politics, when the lawsuit was filed.
Your Honor, I think we can pare this down significantly. So what we would ask is simply a line that says the first. Nothing.
So,
Sorry.
can we have a moment, Your Honor?
Sure.
Yeah, that's
So, Your Honor, thank you for your patience. The committee over here has decided that the only aspect of the charge that we want to stand on here is the piece regarding when the lawsuit was filed. It's at the very bottom of the page.
The date, when the plaintiffs filed the lawsuit, Attorney Pattis.
I don't recall the language, but my sense is I think it's an inappropriate charge. The claim is that from 3 hours after the shooting, Jones caused them extensive harm. I think this jury is entitled to wonder and may well wonder why it took them 5 years to file the suit.
Well, I think that's where the injected politics.
Exactly, that's why we need the charge, Judge.
So I think that it merits some clarification. So maybe just one sentence. you know,
May I just point one thing out, Judge? Based on what Attorney Pass just said, his argument, he said that Jones had made the statements within 3 hours, correct. He wants the jury to draw an inappropriate inference from that, and that's why that's why.
Well, I'm going with the sentence, so you don't need. What do you want me to change my mind?
Should I sit down then?
Yeah.
Thank you, Judge.
The date on which the plaintiffs filed the case is irrelevant to your considerations, and you should not consider that in any way in determining the damages on this case. I don't see how it is relevant and how they should consider it. So there's nothing wrong with that sentence.
We take an exception.
I understand.
So then the only question, Your Honor, is where does that go? It strikes me that ought to just be its own standalone. I'm not sure where it would go.
Maybe after causes of action and before intentional infliction of emotional distress.
That makes sense.
Oh, Ron, can I see you for a second? So I want to finish this. I don't think it's going to be more than maybe 1:15. I asked her to say, do you have somebody else who can come in for a little while?
I can check on the girl. I don't think she'd have a problem with 15 minutes.
I'm not asking. I want to go after 1, but I don't want you to stay because it's been a long day. So I think we're probably going to go up another 1:15 or so because I want to get done for the day.
She's saying it's fine to stay.
I'm not asking. I don't want. Thank you anyway. It's too much. All right. So missing videos. What's this? Number 4.
Yeah, and Your Honor, on this one, there's also, we thought that this needed some support from the record so that there's a motion in support of this charge and a revised proposed charge in that motion. That's docket number.
So can we skip this and then get?
Let's skip this.
Okay.
And then the very last one in here is the charge on playback of videotape depositions, which the court's already given and does not need to give again.
Okay.
So that takes us to the end of this.
Sure. So what's the next document we're looking at? And my plan here, I want to finish and then adjourn for the day, just so you know. So we're going to.
Right. So I think
you
the
agree with
next
that decision, Attorney Pattis?
I agree, Judge.
Yeah.
All right. So the next one.
Taking them in order, the next one would be life expectancy. That's docket number 1005. And we. Yes.
So I think at sidebar, I suggested all the factors in 3.410 be charged. Having had a chance to read through it, I would agree that the first, second, fourth, and fifth can be eliminated.
First, second, fourth, and fifth. Of the list?
Yeah.
Yeah, that's what I was struggling with the lead in here under the facts of this case, but.
Do you want to just talk to each other real quick and see if you can efficiently do it that way? Thank you.
Yeah, I figured we went. Future, you should consider it probably that they're alive. Oh no, before you get to that, you have to have a lead in. That's my view. But this says if you award damages, and we know they're awarding damages, so. Well, we don't. We don't know that they're going to do more than nominal. In your award of damages, you should consider. Okay, what is it? They're proposing that. I'm proposing that.
I hope you're not offended that I didn't ask you to stay late, but here's the thing, I don't like to do that because no one ever says
As a courtesy
and then
to you,
because I feel
I'm
like
avoiding saying, if any.
say no, and that's why I just don't
Your award of damages, you should consider.
be pushy or imposed, you know what I mean? Because how hard would it be? I understand, I tell Ron all the time, people have lives, they have lunch plans, you know, that's. Well, maybe you would, but like, some people would never, even if it was a problem, so that's why I always like have the policy, don't do it.
So what are you saying, sir?
Thank you.
But if
Okay.
in your award of damages, you should, when you.
All right, did you
well,
work
this
it
should-
out?
This should come on the heels, this should come on the heels of the, we're just trying to line this up, Judge, with
Okay.
with the part of the charge where the court instructs on future damages.
Okay.
So once we find that part, I think we can bridge it to this.
Your Honor, I wanted to point out, just because we have not yet addressed verdict forms, and I think that is an area where we're not very far.
Okay, let's finish the charge first and then figure out when we're
Okay,
gonna do that.
I just wanted to alert the court because I was concerned about
Okay.
lunch and staff.
All right, well, we're gonna get through the
Timing.
charge before we take our lunch break.
So what we want to do.
Or starve?
We want to.
Well, do you,
I just need to-
work that out with?
Yeah, it's already worked out.
Okay.
But we just need to, I just needed to see if it lines up, because it needs to
Okay.
be rich.
Okay. So,
In your work for future damages, we should say.
If you award future.
No, she's.
so it's gonna go, I think it would go after cut and before suggested
No,
amount
but I
of
thought,
damages.
where is the, I just want to, what is the court having, what will it charge on future damages?
It will have charged in a couple different places, so. Let me see.
In terms of future damages? How about this one? Which tries, how do we have to say the words with the language? In terms of future damages.
Miss Ellis can come in, but she'll have to shut down and she'll have to restart. That might take 5-10 minutes.
Well, we'll go to one, yeah.
That's no point.
Sure.
We have a different court reporter starting at 2. That's why she doesn't mind staying the 15 minutes.
In your consideration of damages,
I think you just have to say future.
you should consider
I may, do
Yeah.
the
probable
afternoon,
length of the plaintiff's
like
life.
3 o'clock or something, and do it remotely. And do the,
Yeah.
It's not taking at least
That's
over.
my, I'm going to consider that. I'm taking fellow Scrivener's highest respect, adopting your
Right,
language.
so how does it work then?
But that's what we just have to see if it works. Okay.
This is the damages compensatory charge. Comes before.
no, because I think there may not be much left, and we may just end and then do the
Defamation damages.
verdict form.
And
Let me see.
she charges.
Let me ask. Can I interrupt you for a second? I'm just trying to figure out what to do with the court reporters, if I'm having someone sub in or not. After this, putting aside the verdict forms, how many more issues do we have?
We have, unless I'm missing, we have the missing evidence charge. We have verdict form, Attorney Pattis had proposed interrogatories. And I think that's it for charge and motion issues.
All right, so once we do the interrogatories and verdict form we'll do after lunch. So you'll talk about this, then we have one more issue on the charge.
Yes.
Okay, so that's good, so we don't have to switch on, because we might end on time at the rate we're going.
I think we do it back in the, see, I think the bridge is that, that's one, I think that the bridge, because it's gonna come out on its own right now, is she gonna pop us right in? To there, is that what we're talking about?
So.
Should they, should
I would,
we know we should
so
do
go
it,
here, it could go there.
use of the word future there. So my proposal is, in your consideration of future damages, you should consider the probable length.
Yeah. That's good.
And then we agree, just start it.
Eliminate all five of the factors?
Gotcha, yeah.
Okay, that's fine.
All right, so you worked that out?
And then we do the plaintiff's bias.
Oh, right.
Right, then we do, according to the standardized tables,
Right.
name plaintiff and the life expectancy, and then all this standard.
Yes, stuff.
We have an agreement, Judge,
We have
but
an
it's gonna take
agreement.
a little bit of housekeeping on our part, but we can do that not at the court's.
Okay. All right, so then we have the last item
Should
is
we
what
put the
it,
agreement on the record, Judge?
beg your pardon?
Should we put the agreement on the record or not?
Well, when we come back on the record after lunch to work on the interrogatories and jury form, we can do that then. Put it on the record. I just wanted to get to the last issue. I just don't know what entry number it is.
Okay, so we got.
Okay. All right. And I just want to make sure I know about where that goes. Okay. Your Honor, the last issue for the charge is the motion regarding missing videos, website analytics, and social media analytics. And we had proposed a charge on that with regard to...
Is that entry number 1006?
It is, Your Honor. So we felt like it was important for the jury to be alerted to the fact that the defendants did have an obligation to produce some of the materials that they heard about, because we're prejudiced by the absence of those materials in our ability to prove damages. And of course, the court's familiar with the...
This is a testimony of Mr.
Yeah.
Watts.
The testimony of Mr. Watts, the testimony of the witnesses, and
Ms. Paz.
Ms. Paz, right? The missing videos, the missing social media analytics information, the incomplete Google Analytics information, which isn't just established, obviously, by the testimony of Mr. Watts, but the court had recently reviewed the Roddy affidavit, which established that there were some abilities that the defendants had with regard to Google Analytics. We obviously never received that production. So there is...
So here's what I'm going to say. I hear what you're saying, and a normal person who's not in the profession, a normal juror is not going to understand where the obligations lie and might fault the plaintiffs and think that you didn't do a good job. However, you got a book. This is a sentence or two. You have literally 5 paragraphs. Like, it's a sentence.
My contention is that the plaintiffs have reaped abundant benefit in terms of both the default and limitations on what we could say, including the extent of videos, including arguing, non-profiting from these things. And we've adhered to those rulings, and I think this is lily gilding at this point.
I understand your position. Nonetheless, it's very confusing to a jury, and they may fault the plaintiffs for not doing a good job or feel like they didn't meet their burden of proof somehow. So I think 1 or 2 sentences, and probably 1, is all you need, and there's no need to overemphasize it.
Your Honor, would the court like us to work on a sentence?
No, let's do it right now.
Okay.
So can you just describe for me in a couple words what we're talking about here exactly? Is it the analytics? Is it the videos? Is it, what is it, just in, not without argument, just the words?
Attorney Matty's gonna do it.
Just the words.
Videos?
Infowar videos?
Yes.
Okay, go ahead.
Social media and marketing analytics. Google Analytics, there's different. Financial data.
So can we, what if something along the lines of evidence was presented? I don't know. Of Infowars videos, blah, 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 based on what was produced by the defendants?
Well, it wasn't all produced by the defendants. We did a lot of this on our own. You know, like they didn't give us stuff. We ended up finding it from other sources in certain cases, but in other cases we weren't able to.
Well, so are you essentially saying the plaintiffs had no ability to present all the Infowars video, social media, and marketing analytics and financial materials? Essentially, you're saying because they were not all provided by the defendants?
That's correct.
But and sorry, Your Honor, but also that the fact that we couldn't present that, you know, I mean, one way it shouldn't be held against us, but since we bear the burden of proof, you know, that's where the request for the inference comes from.
There's no evidence to suggest the defendants could have produced it themselves either, though, given the state of disorganization there.
But that's not the case at all.
Well,
Listen, Attorney Pattis is right. You've already had the benefit of the default, but I can see where you might want to somehow clarify that you know, that they...
How about the following, Judge? The plaintiffs
Okay.
should not be penalized for their inability to produce a complete record. In other words, you should not draw an inference against the plaintiffs for their inability to produce complete records as to this, that, and the other thing.
Or you should not hold it against the plaintiffs?
But it's more than that, Your Honor, because the problem is that we bear the burden of proof on damages, and this impacts our ability to bear that burden. And I think that was perfectly clear in the testimony of Mr. Watts, who did extensive.
Well, they'll have that testimony, and you'll be able to argue that. But so if we can't come up with something in a sentence that's appropriate, and you know, you clearly don't want the jury to hold it against you for not producing the missing information that was referenced by Ms. Paz or by Mr. Watts. And it wasn't produced,
correct.
and it was missing not because you didn't do the job, it was missing because it wasn't produced by the defendants.
So we could do something like, we requested this information and they withheld it.
Well, I disagree. I was involved in this. They didn't withhold. They couldn't find. They don't have all of this. This is not CBS. They didn't keep a catalog of videos. They never turned it over to me.
This is information.
How about something along the lines, you know, you've heard, however you want to say it, you heard testimony from Ms. Paz or Mr. Watts about, whatever we're talking about, missing information related to analytics or whatever, right? That's true. And then say something along the lines, just give me 1 second because I just lost my sentence. The plaintiffs had no ability to present that missing information to you. And you should not hold it against them, something like that, neutral, that's the truth. They did hear evidence about a lot of missing information, they did, from Ms. Watts Ms. Paz and Mr. Watts. The plaintiffs had no ability to present that missing information, and you should not hold it against the plaintiffs. So that if they're left to wonder, well, gee, all this stuff is missing, why didn't the plaintiffs do their job? Why didn't they meet their burden of proof? You want to say why they had no ability to produce it?
No. The issue is, Your Honor, that we've spent a lot of time working on how it's our burden to prove, and so don't hold it against us. It doesn't
So
solve
just,
the problem.
I understand. So say it neutrally, that, the defendants did not produce that information. It's neutral. That's the truth. The defendants did not produce it, and so the plaintiffs could not present it to you, and don't hold it against the plaintiffs. That's the truth of the matter. The defendants did not produce it. We're not taking it any further. They've already been defaulted. So that's the language I like.
Okay. Certainly understand the court's preference. I think we would need to accept there because we still.
Well, you're both going to accept to this, so I have managed the impossible, haven't I, on one sentence?
So I think, Your Honor.
Well done.
So I think I have what the court's preference was.
Do you want to read it so that I can?
I think we have to fill in some information, but it was.
Well, I need to I need to know that the charge is done.
Yeah, no, I understand.
Well, we may not, excuse me, sorry, it's getting towards lunch. Everybody here is hangry, I don't know about you guys. But this is kind of a big issue for us because of not wanting to be penalized for their failures, their almost historic failures that have gotten to us to this point. And so it's not just a matter of deprivation of the material that led to the default. It's adding to that a burden here in court to prove things, and we're handicapped from that through no fault of our own. In fact, through fault that led to a default. So it's not enough, in our view, and I appreciate the court's right as far as the court has gone. I don't dispute that. It's just that we need it to be known that this is adverse inference territory we're in. We just need it because otherwise we're being punished for the wrongdoing in the discovery of the defendants. And so if we can just and more to the point, since it seems that the court has shared the court's preference on this, we need to talk about whether that does more harm than good.
Judge Mike, this is filibustering. I mean, short of default, I can understand the need for a strong adverse inference charge if the jury was going to decide the issue of liability. But we were defaulted. There were additional sanctions awarded even on the cusp of evidence based on late disclosure, limiting what we could and couldn't say. The combination, with respect to those recent limitations, they had a material bearing on my client's willingness to testify. It seems to me that the plaintiffs have reaped ample benefits from these failures, and that this is overreaching.
But we are trying this.
I understand, but here's the thing: I could have told them the reason for the default all along, and I did not. So they are here not knowing any reason why it's a hearing and damages and why they're just addressing liability.
Which we think prejudices us. We requested that they know the reason for the default.
You requested that they know that they were defaulted for.
We wanted to produce your ruling on the default as a piece of evidence, and there was argument on it. It was denied.
I think. Go ahead.
You wanted the transcript, and I did not want that transcript.
Exactly.
That's what you asked for. You did not ask ever for the reason for the default.
Well, I think
then maybe this is
the reason for the default.
Well, then maybe this is the point where we could address that.
At this point, because now the case has been tried, there were things I could have done with that information, which was the point
Right, but you never, you asked for the transcript, not.
Well, I mean, that's a distinction without difference, then, you know.
No, I disagree, Attorney
I'm saying I
Pattis.
want the word of God, I'm a Christian, I asked for a Bible, well, you know, I mean, you know.
All right. So, something along the lines, if, you heard evidence from Mr. Watts and Ms. Paz regarding missing whatever. The defendants did not produce these materials to the plaintiff, and therefore the plaintiffs could not present this evidence to you. And then some neutral language, another sentence maybe after that.
So we could write that out for ourselves, Your Honor, but then I think we would need to talk about whether
Right.
we would ask the court to charge it or not.
Sure. All right, so what time do you want to pick up on this issue? You're gonna work on the life expectancy, we'll put that on the record. The interrogatories and the verdict forms. What time would you like to meet again? 3?
For the court.
Yeah, I'm at the court's
So,
disposal.
We'll defer to the
3
court.
o'clock is fine.
3.
Okay, sounds like a plan. Okay, and just for tomorrow, how do you want to break things up?
Judge, I had, you mean in terms of lunch, before lunch, after lunch?
Lunch, recesses.
It seems to me that that may be a little bit of a play-it-by-ear situation, depending on how long things go. I just wanted to alert the court, Mr. Matty's going to be doing the summation, and I'm going to be doing the rebuttal. So we know how much time we have to work with, but I haven't done the math to see what would work. Whether, you know, Mr. Pattis.
Right, but how do you
whether we have an early lunch and Mr. Pattis does it after lunch, or.
I don't want to be in Carbo Valley.
In what?
Carbo Valley. Carbo Valley. So, how about we leave it like this? Whenever you want your recess, you can ask. So if you would like a recess, say they go and you're up and you feel like you need a recess, just ask for it. Or talk to each other and let me know. I'll be flexible. I'm not, however it works out for you.
Okay.
I mean, I don't know how.
Like a morning recess rather than a lunch break or something like that.
Yeah, actually, we should be done, well, I don't know.
Well, we start at 10.
I won't take 2 hours.
How long are you gonna go, Attorney Meddy? Have any idea?
An hour to an hour and a half.
So let's say that takes us to 11.
So mine could go to the morning lunch break.
Okay,
I don't think it'd go longer, I doubt it.
okay.
Probably a little shorter. So if I had a little shorter, is what you're suggesting that if Attorney Pattis wanted to, we could take the morning break before 11:30 if you wanted to, rather than start.
Sure, and then, you know, I think we can sort of play it by ear too, because I don't want to break up his close with lunch.
Right.
For sure. So maybe I could work something out with the court reporters. I don't know, I hate to do that.
Well, if Attorney Meddy can go for an hour and a half, Judge, we're at 11:30, we come back, you know, I don't think I'm gonna be more than an hour. I mean, I haven't heard the closing, but I heard the case.
So you think that let's put it this way, we'll make sure that we work out in a way that your closing isn't interrupted by lunch. I mean, it sounds like it'll work. And if we have to take lunch a little bit late, so, you know, say something happens, say you go longer, and or we'll shorten the morning recess if the staff doesn't mind, so that we'll get you done by lunch.
Thank you, Judge.
And then, so that sounds like a plan. All right, so I'll see you folks then, 3 o'clock. I'm gonna do it remotely.
Okay.
So we're gonna do it on the computer, so you can go back to your offices or wherever you are.
Judge,
Don't we have to stay for purposes of the exhibits?
Oh, you do. Indeed, you do. Indeed, you do.
Tough luck for us.
It's a good point. Let me figure that out with Ron, and I'll let you know in our coffee break room in 2 minutes, okay?
Yes, Judge.
All right, take a recess. Sorry about that. I thought we were gonna be done right at 1, and what I did was Okay. Where do you want to start?
Good afternoon, Your Honor. Eleanor Sterling with me again, or Josh Koskoff and Matthew Blumenthal. With regard to the charge regarding the missing information, we have a proposal for the court. Why don't I try reading it first because it's a little messy. You have heard that the plaintiffs requested all Sandy Hook videos broadcast by the defendants and all analytics regarding Infowars social media, website and marketing materials, and financial data. The defendants did not produce complete information in response, and as a result, the plaintiffs had no ability to present the missing information to you. Period.
I think that's close to what the court indicated was its preference.
Can you do it one more time?
Of course.
And so without me checking my notes, there has been evidence along the lines of those first two sentences for sure?
Yes. But, yeah. Yeah, we don't
I thought it was that, well, wanted to read it again. I just didn't think the evidence was that they didn't produce it, like during discovery. I thought the evidence was that, I don't know, read it again.
Well, so it's different with regard to different information, right? It certainly was all requested. And then...
Oh, that wasn't, I'm not sure, was that the evidence? We requested it?
So there was examination of Brittany Paz about what was requested.
But I don't think the evidence suggested that that was all requested, that came in through Ms. Paz.
What if we said, since we're a little bit uncertain, we could say, hold on a second.
I mean, it wasn't made available to you, and therefore you could not utilize it.
That's what the punchline is here.
Okay, that's a sentence.
But it has to be established what it was that we. I mean, I think putting aside
what if it doesn't say you have heard? It just says the plaintiffs requested all Sandy Hook videos broadcast by the defendants and all analytics regarding Infowars social media, website, marketing materials, and financial data. The defendants did not produce complete information on it in response, and as a result, the plaintiffs had no ability to present the missing information to you.
Because I just don't know if the evidence is that all of that was requested.
I take the plaintiff's point in there, without agreeing to this and waiving my prior objection. I think that last iteration avoids reference to the evidence and incorporates the activity of the case as a whole, discovery included. So if the plaintiff's fear is that the jury will hold the lack of information against them, what this tells them is wherever, whether here or in trial or in discovery, the plaintiffs requested complete information as to X, Y, and Z. The defendants did not produce it. As a result, the plaintiffs could not do Y, whatever that is. I object to the charge at all, but I think if you're going to give it, that's a neutral form, and it avoids the problem of what the evidence was in the case, and is true to the record of the case as a whole.
There's also some spoliation case law, Your Honor, that says that the court can charge in a way that takes into account the history of discovery. Not every.
Right, but what was proposed was you have heard that we requested, and I'm just not sure I
We're
heard
backing
that.
off of that.
Right, we are.
Yeah.
So I'm
So let's go to the hopeful final version.
Okay. It says the plaintiffs have requested all Sandy Hook videos broadcast by the defendant and all analytics regarding Infowars social media, website and marketing materials, and financial data. The defendants did not produce complete information in response, and as a result, the plaintiffs had no ability to present the missing information to you.
It's pretty neutral. Anything to add to that? I know you're objecting to it, but,
If you're gonna get it, that's the way to get it.
all right.
Objection.
Can you start it off while the plaintiffs requested? And make it like one sentence? All right, so what's the next issue? Did you work out your life expectancy issues or no?
Yes.
Oh, good. Okay.
It granted me an additional 4 decades.
Your Honor, we plan to submit life tables as exhibits, as well as an accounting of the plaintiff's birth dates and their expected lifespans from today with a charge that's been agreed upon with the parties.
I think the court wants to hear the charge.
Oh, okay. Let's do 1 second, Your Honor.
Take your time.
Your Honor, there's one thing we want to double check on the missing information charge. If we come back to the court, it will only be with a deletion. So we won't.
And just last words.
Yeah.
And six supplemental charges.
I have a feeling those were the last words.
I can do this one.
Sure.
Okay, so, Your Honor, this is the agreed upon charge for life expectancy. It reads, in consideration of future in your consideration of future damages, you should consider the probable length of the plaintiff's lives. This may be proven through standardized mortality tables and evidence of the plaintiff's age, health, physical condition, habits, activities, and any other factor that may affect the duration of their life. According to the standardized mortality tables, the plaintiff's life expectancy is the following number of years from today. And then it lists each plaintiff's life expectancy based on those tables to the nearest whole number. And then reads, bear in mind, this figure is only an estimate of a plaintiff's length of life based upon statistical data, and it is just one element to consider in determining a plaintiff's life expectancy. You may find that a plaintiff will live a longer or shorter period of time based upon your assessment of all the evidence regarding the plaintiff's condition and the circumstances of their life.
That's agreed.
Okay, that sounds good to me.
Did you want to talk about Yes, there was a line of future damages and compensatory damages, and we were going to insert it right after that, I think.
Your Honor, we also have an agreement about where that goes in the charge. And the plan is to put it in the compensatory damages charge. There's a sentence that says, it talks about future damages, and it closes likely to suffer in the future as a proximate result of the defendant's wrongful conduct, and then that life expectancy charge will get inserted right there. And Your Honor, I'm planning on making these changes and circulating them to you and Attorney Pattis tonight, if the court would like me to do so.
Oh, like I needed them today, as soon as they're done, before you leave.
And that was,
Ron's gonna,
I could do that
yeah.
too.
I need,
Absolutely.
because we could easily pick up on a stray mistake or word or something. And
Absolutely.
I'm not gonna look at it tomorrow for the first time.
Oh, no. I'm sorry, Your Honor.
Okay.
That's fine.
Okay, so verdict forms and interrogatories, is that where we are now?
Yeah, and my sense is that we could use some guidance from the court on this. We're not, we're coming at this from two different places.
I can see
Although we
that.
have had some discussions.
The rulings this morning have simplified my requests.
With the ascertainable loss?
Yes.
Yes.
And we've had some preliminary discussions. I'm intrigued by Attorney Sterling's suggestion that guidance for the court might help us, because we are still far apart. I'll defer to Attorney Sterling on the guidance that might help.
I'm not sure what guidance I can give you. I have only seen and used verdict forms that just simply breaks it down by cause of action, which, you know, so.
I understand.
Everybody
I
agrees.
mean, the issue, I think, with that here would be that it's just confusing and potentially duplicative. You know, that the emotional distress charge that we looked at would be applicable for IED, for a false light, and for emotional distress as it results from damages, from defamation per se, and for CUTPA.
So I imagine you share that concern, that you don't want duplicative damages, right?
Well, here's the concern I have, Judge. Attorneys, the Koskov firm's verdict form has the virtue of elegance, but it might obscure things that are necessary to protect my client's interest. I don't know if the court has my proposal.
Right in front of me.
Okay, so my view is obviously I don't need economic harm given your rulings and the ascertainable loss question. But here's what I was after in this as drafted. By making a finding as to each of the claims, each of the counts, and then I'm able to, as to both compensatory damages and then punitive damages, I'm able to correlate whether the defendants are in fact entitled to punitive damages because there's a unanimity requirement. And so this is almost a specific unanimity argument, and I know that the state Supreme Court just had a series of decisions on specific unanimity in a variety of contexts just 2 weeks ago. But here's what I'm concerned about. If you do what the plaintiffs propose, you can have a plaintiff conclude, you can have the jury conclude that plaintiff A had a breach of privacy, but nothing else. Plaintiff B had defamation, but nothing else. Plaintiff C had intentional infliction, but nothing else. And that's all allocated. And then you go right down to the punitive damages question, but they weren't unanimous. And so so by aggregating the claims, you're obscuring the unanimity requirement as to punitive damages. The virtue of what I've proposed, if there is one, is that by making a finding as to each claim, we're assuring unanimity as to the necessary predicate to get to punitive damages and preserving any sort of BMW v. Gore claim that I might have later, depending on the size of the compensatory award. So I would propose that the court, if it were so inclined, can give my charge as to each claim on emotional distress. If they've not proven it, then they're directed to give it $1, and then in what sum fairly justly and reasonably compensates, and it's either $1 or the sum. And then as to each claim, they have to decide yes or no as to punitive damages, as to the common law claims, and then as to the CUTPA claim. I understand it's the court's discretion to give it, but I'm requesting that they be given a yes or no question there. And that way, my client is assured that the jury made a unanimous finding as to each count for which compensation is sought. I think that what troubles me about the plaintiff's proposal is that it shrouds from inquiry whether unanimity was found as to any claim, because you could have people mixing and matching. I'll give you defamation, but I won't give you intentional infliction. Well, I'll give you intentional infliction, but I won't give you privacy. And the result is we get 6 people deciding different things to the derogation of the unanimity requirement.
We're in a default posture. So there is, I mean, if the jury were determining that, intentional infliction hadn't been established, that would be error.
No, I'm talking about damages as to the counts.
So in the charge that we have just worked through has two categories of damages. Has emotional distress damages, which in our view, although we understand the defendants disagree, are available under all four causes of action, and it has reputational harm, which is available under defamation per se and CUPA. So
I find both these confusing, and I'm having a hard time finding no offense, but I'm having a hard time finding my way to something that's not confusing. I just find them both confusing, and I'm just trying to figure out how.
Well, maybe we should give the court a moment without arguing.
I don't think.
Can I take a crack at it, Judge?
Anybody can take a crack.
So the reason why we settled on these two, if you look at our verdict form, you'll see that under each plaintiff there are two lines. Now, possibly to our disadvantage, you could argue that you could have 6 lines for each plaintiff, right? You could have past defamation per se or reputation, future. You could have past privacy, future privacy. You could have past emotional distress, future. But to simplify it, in part because it is complicated, we felt that really when it comes down to it, there are two very distinct categories of damages here. One are the defamation per se damages. And those are the damages that we went over earlier that are what the law might call general damages, right? Those are self-effectuating damages. That's the issue that you don't have to put on evidence for those. There's a legal inference that is drawn that they are of harm, depending on the nature of the, for lack of a word, the nature of the slander, right? And the reach from nominal. Somebody tells one person a lie about a person of bad character, that's nominal, versus substantial, which we think we have here. But in any event, those are one category that do not turn on emotional distress. The second category are what we could which is another sort of bucket, is the emotional distress damages. And those damages are occasioned here by at least, by the default, for sure, by the infliction of emotional distress claim as reflected in the name itself. And as Attorney Sterling has pointed out, under CUTPA, now invasion of privacy, which could arguably be another line here, is actually considered in the case law one part of emotional distress. So broadly speaking, invasion of privacy is an emotional distress, as are many of the things that the plaintiffs presented evidence on.
I understand this. I've not seen anything like this before, so I'm sort of
None of us have.
reticent. So if I can't figure it out, I'm just going to default to the old-fashioned way of doing it, and I think it's going to be a lot longer, and it's not going to please either of you. But can we talk about the possibility of doing it count by count?
I agree. I think it should be done count by count.
What is the, may I inquire, Your Honor? I'm just trying to find what the court's concern is about.
My concern is that that's what I've always used, and I've never seen it done like this, and I'm not sure this is the case that I want to start doing it with. So since the way that everyone has always done it is count by count, and I've never heard or seen anybody not do it like that, unless you want to give me some appellate court case where it's been affirmed on appeal, and I'm not aware of any. So if we were to do it count by count, which is the only way that I know,
it becomes a, well,
sure,
it's more lines for us.
I mean, personally, I think doing it count by count, there's more possibility of
a breakdown. Well,
Judge, the way I've seen it done in 1983 cases, I'm sorry to keep referring to that, but I've had a lot of experience in those, is the court would list, I mean, and again, this is not a default posture, but let me translate it. Even though we're here on a default posture, the defendants have to prove, they're entitled to the damages they prove. And so, what damages have you proven in A? What damages have you proven in B? What damages have you proven in C? And then there's a cautionary instruction if those damages overlap and are duplicative, that they can't award them duplicatively. And so,
we charge on that already.
That's
So,
why we can't.
I'm not seeing the need for interrogatories, but I think we can do it the old-fashioned way, count by count, without interrogatories and figure out.
Your Honor, I think the reason why I propose the verdict form this way is that the measure of emotional distress damages is one measure.
I understood it the first time you said it. I still understand it.
Yeah, so I get what I'm imagining in the scenario the court is describing is a lot of instructions that this number should be the same. I mean, what my concern would be is that we would end up with a emotional distress number for IIED that's different from the emotional distress number for false light, even though the charge tells them it's the same measure. So that's my hesitation.
Well, I think everybody shares that concern. So how do we avoid that problem?
I don't think we do. I think on appeal, the inconsistent there's a well-developed body of case law on what to do with inconsistent verdicts. And so I'm less concerned about that than I am assuring that as to any money awarded, it's in fact a unanimous verdict, and only count by count assures that.
What happens if we went along? I'm just, again, this is unfamiliar territory to me because I've never done it this way. Is there any way of putting in descriptors or something underneath the two categories of damages so that it links up to the causes of action?
Yes. So if we were to,
I'm just thinking out loud.
Yeah, so if we did defamation and slander damages, and under that we listed these are damages for intentional infliction, false light, emotional distress.
I mean, here's the thing. I try to think of my mother on this jury, God forbid, and she's going to hear this charge on these causes of action, and then she's going to get this form. She's going to be so confused.
I know, Your Honor, that's actually why this charge is that way, because
I know, but it doesn't list the causes of action that I just charged them on, and I just think it's confusing. I don't know how else to say it. Maybe it's not confusing to you because you drafted it and this is what you do for a living, but I think I don't.
Your mother, is it your mother or your mother-in-law?
My mother.
Your mother. I think your mother might be a little confused by this simple two-line form, but I think your mother would probably would be driven crazy by this suggestion that you have. Wait, hold on a second. There is emotional distress here and emotional distress there. I thought we already talked about emotional distress. What about this?
So what about the proposal of adding some explanatory language under the categories?
I think we could try that.
I disagree. I think the locution count by count describes what I'm trying to capture with the interrogatories that I submitted, because my fear is that unless it's count by count, I'm not assured of unanimity, and I'm entitled to that.
The reason why we sometimes do count by count, Judge, is because we have a liability issue. So you have to establish count by count. Did the plaintiffs prove, right? Did they prove?
Can you put some language in there that makes it that you go down to the lowest common denominator? The plaintiff claims emotional distress damages related to their, this, and this.
But Judge, that doesn't capture if only 4 find a sum for IED and 2 don't, they're not entitled to anything because they haven't proven.
I'm not understanding that. Say it again.
Even though I disagree with Attorney Koskov about count by count being applicable only in a liability case. In this case, my understanding is
that obviously it's a hearing in damages, and the plaintiffs must prove to jury satisfaction on per count what it is that they're claiming. So all 6 jurors must agree as to IED, for example, and all 6 jurors must agree as to the sum as to IED. Let's say it's $1 million. All 6 jurors must agree as to the sum for breach of privacy. Let's say it's $2 million, and so forth. Unless it's count by count, there could be less than unanimity, and a total at the bottom line that doesn't reflect that the plaintiffs have met their
They're going to be charged on unanimity, and they're going to understand they can't make any awards unless they're unanimous. So can you give me a breakdown if we did it along the lines of what I'm saying? So under defamation/slander damages, past and future, and then under emotional distress damages, do you think one?
Should we need this once, or do you want us to repeat it for each plaintiff?
For each plaintiff.
Okay, so.
I don't think we need to give them the count numbers because they're not getting the complaint. I mean, normally in a simple case, we give, count 1, negligent infliction of emotional distress. Count 2, intentional infliction of emotional distress. Count 3, breach of contract.
You want us to have the.
If we're going to go along the way that you have it, which I think avoids overcompensation, actually. I think this actually benefits the defendants.
Well, I disagree.
Right. I understand you disagree.
For specific unanimity reasons.
Right. But I think that would sort of.
We can do that. But
so lay it out for me now and let me see what it looks like. So.
Because Josh, Attorney Pastor was saying we can do that, and I'm not understanding what he means.
Well, I think I'm following the court. The court wants us to, under the proposed plaintiff's form, we have defamation, slander/slander damages, for example, for Robbie Parker, right?
Right.
Okay. So what I think Your Honor is saying is that it would be helpful, with your mother in mind, to have have us reference infliction of emotional distress.
This applies to
yes.
If I'm charging the jury on all these causes of action, and now they see this, it's confusing.
Got it.
But I don't want to get hung up on appeal on a general verdict issue. Well, I think interrogatories are necessary because they pled multiple counts. If they want to withdraw 2 or 3 counts because they're not necessary, fine. But I'm not going to go down. This is a hill I'm choosing to die on. Sure. I am not going to stand by idly, absent every assurance that whatever sum is arrived at is unanimous by count.
Well, that's not. I don't believe that. I think that Mr. Pattis respectfully is really referring to issues related to liability.
No, I'm not.
Hang on one second, Mr. Pattis, not finished. And not to damages. And secondly, I can't even remember how many times I've submitted special interrogatories only to be told no, and that protects the submission of interrogatories, whether they're right or wrong, protects your record on general verdict. You don't have to worry about that because you've covered yourself. And it's not a reason to have this jury completely confused and scratching their heads and turning to deliberations that ought not to be that long.
I literally found both sets confusing, and so if I'm confused, I'm thinking they're going to be confused. So let's try to figure out how we can be accurate on the law and not confuse them.
I think we're going to have that to you momentarily.
So as I'm understanding it, Judge, under the defamation, so keying off the plaintiff's verdict form, under the line to plaintiff Robbie Parker, it would say defamation/slander damages past and future, and then there would be a parenthesis that says this applies to defamation per se and cut but counts. And then under emotional distress damages, there would be something that says this applies to intentional infliction of emotional distress, false light,
defamation per se, and cutback counts.
And that avoids the question of requiring unanimity. It's not enough to be unanimous as to sum. It's necessary to be unanimous as to count.
That's just inaccurate.
It's not inaccurate.
It's not. And of course you would like to break down defending a case to something so fine and so detailed that you could never, that it just breaks down. The court is going to charge that they need to be unanimous in their verdict on damages. That's all that's required. And this verdict form is in service of that. It also has the advantage of being clear and concise.
So I don't care for the interrogatories. If we didn't do it this way, which I think might be the best way, then the only other way I could see doing it is just the old-fashioned way, no interrogatories, and which you've got your record protected, and then have it by count.
I would agree with it. If I can't have the interrogatories, I would prefer it by count.
But then
it breaks down. It's going to be. Imagine being. I think the court had the perspective that I think is appropriate. Imagine sitting as a juror, whether I'll speak for myself, whether it's me or my mom, who is smarter than me, so it's probably not a good example. But whether somebody, just anybody sitting on there and trying to figure out why we're being asked for emotional distress as it relates to CUTPA.
All right. So how could it? So if it was that way, what direction could you give them to? I can't even imagine what we. Let me just ask Attorney Costco first. What direction could we give them on a verdict form that avoids conflicting results?
What we just hammered out on for the.
No, if we did it the old-fashioned way.
I can't think of one that. I mean, when the court says the old-fashioned way, I think it's the way in many, or if not most cases. But this is not most cases, and that way is very much intertwined with liability.
But I'm asking if it had to be done that way.
I can't think of one. I think honestly, it invites major error in the case. There's no reason to do that.
It doesn't invite any error. It would be as to count one, intentional infliction. What sum have you found as to Robbie Parker? What sum has you found as to William Sherlock unanimously? As to count two, what sum have you found as to each of these individuals? And then we would at least know that all six agreed on each sum per count.
And then how does that avoid the conflicting verdicts?
I don't know what you mean by a conflicting verdict.
I think that.
Here, let me tell you how it might work. If the court were to find that 5 of the 6 agreed on a sum as to defamation, and that 4 of the 6 agreed on a sum as to breach of privacy, the court would then say you've not reached a unanimous verdict. You must return and resume your deliberations. And if they involve themselves in horse trading at that point, behind closed doors to come up with unanimous sum per count, at least I'd know I got.
Well, there's always that possibility, and we assume that they're going to follow the charge. That's what we assume.
Well,
that is what the assumption
why not
is.
Submit a form, how much money, period. The reason we don't do that is we want to make sure that they're following the law and give them appropriate
counts. First of all, that is done. And second of all, the counts don't matter when it comes to taking $1 for emotional distress from this count versus that count. They're the same. So that doesn't.
It doesn't matter in the dollar context, but it matters in the tens, if not hundreds of millions, which is what will be argued.
The measure.
And unless they're unanimous as to a sum per count, they get nothing other than $1. They don't get to mix and match.
I don't want the court. I don't want us to talk ourselves into an error here.
Neither do I.
Error. I appreciate the comments, but. And, this is where maybe being 100% a civil lawyer and not involved in damages cases is an advantage. But, the measure of emotional distress damages is the same for all causes of action. The measure of reputational harm is really defamation per se. That is as clear as we can get in this case. It is not, the de rigueur way of doing things, which, by the way, I have had many cases, and I'm sure the court has too, where the court does just put one line for damages or 2 lines.
I don't
That is
know.
very, excuse me. That is very common as well.
What about some language, this applies to defamation per se and cup accounts, and your award must be unanimous for both counts? That deals with your issue, right there. That's a good instruction. That's what you want. You want to be unanimous for both. Let's just tell them the truth. Just tell them the truth. That's it, and make it.
That works.
But it can't. But it's not unanimous for both, because unless it's unanimous for each, it can't be unanimous for
So
both.
give me some proposed language.
About track the interrogatory. And I just want to once again
Just give me
request
some-
that
just
we avoid
without our-
ad hominem stuff.
just-
I've tried as many civil cases as I suspect that
Oh,
Mr.
man.
Kosloff has, and I'm just getting sick of it.
Okay, all right.
May I
Come on,
try?
let's get through
But
this.
I think the interrogatory addresses.
I understand that, but I don't like them. I'm sorry. I
That's
don't like
okay.
the interrogatories. I don't like their verdict form, and I'm trying to make it work. So just bear
Count
with
by
me.
count.
No, just give me the language that you didn't like my language, which I'm not offended. That's fine. So this applies to defamation per se and cup accounts, and you must be unanimous. Give me some language that deals with your issue.
As to each plaintiff, there should be a separate line per count.
That's crazy.
Again, there we go with the ad hominem.
Okay,
stuff,
well,
Rich.
that was not, that
I didn't
wasn't.
say that was great. I just said, sorry. So I apologize. It's not crazy. It's wrong, but it's erroneous.
Okay,
It's
listen.
not either. I mean,
So, this applies to defamation per se and cup accounts, and your verdict must be unanimous for both counts.
as to each count.
Your decision must be unanimous as to each count. Not sure what that means.
Well, that's the problem.
Well, no, let me just think about it, Attorney Costa. So what does that mean?
It means that that they can't swap. They can't.
Keep going.
In other words, count A, whatever it is, if 6 people give $100, that's $100. Count B, whatever it is, if 6 people give $500, that's $500. What I'm proposing avoids is a situation in which under A, 3 people give 100, in B, 3 people give 500, and they conclude, well, okay, we'll give them 400.
So I like sort of the language. Why don't we add a paragraph into our charge and go over the verdict forms with them, and you can give me some language to tell them. I've had to do that before. I don't usually enjoy it, but we could do it. We could give them the verdict forms and discuss it and take care of Attorney Pattis's concerns and your concerns. But I'm sort of now liking the breakdown by plaintiff with the explanations.
I think you got them in. Here's the thing, Judge. We will of course do what the court instructs, but I don't want to snatch problems from the jaws of this court solution. I believe the court has just addressed the concern adequately. First, more than adequately, because we don't think that there's a.
All right. So this is what we
solution
have
in search
so
of a
far.
problem as far as we're concerned.
Defamation/slander damages, past and future, parens. This applies to defamation per se and cup accounts, and your verdict must be unanimous
Sure.
as to each count.
That's perfect.
That's,
The court
well, that
doesn't
was
have to
Attorney
do
Pattis's language, and I think you,
No, we agree as far as we go. But I don't think we have to talk about this anymore. I think that that's a solution to a.
all right. So you're on board with it. What do you need, Attorney Pattis?
I need to be sure that they are unanimous as to their
Tell me-
dollar amount as to each count.
Do you want me to go over the verdict forms with
Yes.
them? And so give me something that you want me to say, and let's talk about it.
The plaintiffs have sued, each plaintiff has sued the defendants under 4 counts. You must be unanimous in your verdict as to any count in which you award. You must be unanimous in your verdict as to each count. As to the count of defamation, do you award? Are you unanimous? Yes. If so, what sum do you give? As to the count breach of privacy, are you unanimous? Yes. If so, what sum do you?
I'm not going to do interrogatories, but can you give me something that I can say to them?
If you can say that.
Your Honor, but
thing is, that sounds as if they're making a liability.
It does, and I
No,
so
that's the issue.
I agree.
That's
So
a red herring. The question here, we all agree, and I mean, we keep coming back to this, not, unless and until they prove more than $1 is all they get. And they have to prove that as to each count, or they get nothing. They have to be unanimous as to each count, or at least as to one count to get anything. And the way that this is proposed is we'll never know that they did that.
If our goal was a mistrial, then that's a great way to get it. But that's not our goal here. And
No.
the courts found a middle ground here, and it's not our idea, but we understand the concern of unanimity of the damages verdict. If you put it on the form, that's about as much as you can do in addition to instructing them, right? That's as much assurance as you can, and there'd be no reason to think that the jury's not going to follow that.
So is there any reason we can't put something about go over the verdict form with them, with language that you give me, or just add something to the charge about the unanimity and the verdict form?
I think that in my experience, and I think the courts, you typically would say something about the jury verdict form, right? So whatever we end up here, I assume is going to be in the charge. None of us at this table, with all due respect, are understanding this argument other than it is inviting it's again, a solution to a problem that doesn't exist.
No, I mean, I'm looking for a mistrial. No, I'm here to defend my client's rights. And my client has a right to unanimity as to each count before they get indicted. And I could characterize my adversary's motives and say, well, if you want to get a quick buck, just keep the jury from deciding the actual issues. But I'm not going to do that. I am going to insist, however, that we know that this juror unanimously agreed on the dollar amount per count. Otherwise, I don't know what I'm looking at when I get a verdict.
That's not a thing. I'm sorry. So why don't we, before this goes totally off the rails, I think that Your Honor has given us guidance, and I think we've, on the form itself, we know this is wrong.
Right, so I think that we've made some headway. I usually have a line that says something, total, fair, just, and reasonable damages, and it tallies it up. You don't do that here. Is there any reason why not?
We're going to rewrite this form for Your Honor's order. So
well, I'm just asking you, it's not there, and I'm wondering why not. Is it something that you would agree that is a good idea? Attorney Pattis, not a good idea? Tell me, it's just not there. Usually you see something that says total, fair, just, and reasonable damages.
I think it should be there, excuse me. I think it should be there, but we've had argument, you've heard once before argument that we shouldn't include that in the charge.
Shouldn't include what? I'm sorry.
Fair, just, and reasonable. Presumably that's as culturally inappropriate as asking that they use cool deliberation. But Judge, I think we should just take a break, because I've lost my temper in this with what I think to be disingenuous argument, and I've had my motives attacked from day one in this case, and I'm sick of it.
Heavens, why don't we just both take a deep breath, because I'm going to finish this up now. I'd like it tallied up, total, fair, just, and reasonable damages, and they add the number up. I've never not done that in a verdict form.
There
ever.
should be a total here for each one.
Right, so total, fair, and then they add them up, and then they add it wrong. I got to send them back to re-add it right. All right, so what I have is the breakdown that and I feel strongly about this because I don't see how we explain to them in the charge these different causes of action, and then they never hear about these causes.
We have a solution for that.
All right, so I think that we'll do that. We'll add Attorney Pattis's language, which I like.
About unanimity.
Your verdict must be unanimous as to each count.
Yeah, as to each, right. I think
or each cause of action. I don't know. Attorney Pattis, you said count. Do you want cause of action? I think cause of action is better.
That may make more sense.
Than count, because they don't even, as to each.
No, I don't, sorry, Judge, that's not, the counts, they come into this case having a unanimous verdict on all counts because of the default, right?
No.
So they just, They just have to be unanimous on the damages. That's all. It's not as to count.
Well, damages as to count, then that's
No,
fine.
it's not the law. It's just not true, and that is manifest error.
It's not manifest
And there's
error.
no reason to, there's absolutely no reason to do it in this case.
Judge, there's every reason to do it, and the reason is that this is a hearing in damages, and they've been told that the plaintiffs are entitled to damages for
All
what
right.
they prove by
How
count.
about if we just say, and your verdict must be unanimous as to
Just
your
period.
award for defamation per se and CUPPA? And then we're not calling it a count, we're not calling it a cause of
Sorry,
action.
defamation- You mean, excuse me, Your Honor, I think, just to be clear, I think you may have meant defamation, slander, or sorry, defamation damages and emotional distress damages.
No.
No, I said what I meant what I said. So for example, defamation and slander damages, past and future, then parentheses, this applies to defamation per se and CUPPA counts, and your verdict must be unanimous as to, now I forgot what I said.
As to
Period.
No, as to
for these.
both defamation per se and CUPPA counts.
I think that's where the problem is, because what does that mean to the jury? We're not talking about liability.
Well, I understand that, but we said this applies to the defamation per se and CUPPA counts. So we say counts, and your verdict must be unanimous as to each count.
But
That's what we originally had. That's what we originally had from Attorney Pattis that I liked. That
I think we understood you to, excuse me, Your Honor, we understood the court to be saying that the verdict must be unanimous, not as to the count, but as to the damages. That's what it has to be unanimous on. The count.
As to the damages for each count?
Just to the damages.
No, I disagree strenuously. I think that the least.
Nobody wants to retry this case.
It will be retried. If
Okay, all right, let's not get, let's back up.
I'm absolutely certain.
I just think that if the goal is to make this understandable by the jury, which is the goal, the first, second, and third.
How about as to these counts? That's what I'm gonna say.
I say each count, Judge.
It's the same
Otherwise, I
thing.
don't know. If they gave 400,000 as to one, 300 as to another.
Listen,
and they weren't
Attorney
unanimous.
Pattis, listen to what I'm gonna say, because it's exactly what you needed.
I'm listening.
This applies to defamation per se and CUPPA counts, and your verdict must be unanimous as to these counts. That's exactly what you wanted me to say. You wanted a unanimous verdict as to those counts.
As to each count, correct.
I mean,
As to the defamation per se count and the CUPPA count.
And then the others. Because otherwise there'd be.
What's the problem with
I
that?
think he's leading us right headlong into
How though? Explain.
Because it's not required by the law, A, and B, it invites them onto a different universe. What are they talking?
So if we
it's
broke
not
it up
this
separately, which is how we normally do it, they would have to be unanimous in their verdict as to the defamation per se
house.
damages.
Here's what would happen. If we broke it up separately, you would have, in a typical case, which is what the court is contemplating, you would have the plaintiffs prove negligence. Have they proved that negligence was a causation, right? Then they would go to count 2, negligence, causation. Then they would go to count 3, negligence, causation. 4, negligence, causation. And then they would get to damages. That's how it's done. It's not, damages are not broken up by count. Liability is broken up by count. And that's the manifest misunderstanding here.
Plaintiff's verdict or defendant's verdict broken up by count, economic damages, non-economic damages, line.
Not by count. You don't break up damages by count.
I disagree. That's the whole point of
I've
having a hearing in damages.
only done it broken plaintiff's verdict form, defendant's verdict form, which doesn't apply here. First count, breach of contract. This line, total fair adjustment. Then the second count. Then you break up. We're not going to do that here. I've sort of adopted your suggestion, but
So, Your Honor, may I? In the charge that we spent so long working on, some of this is already addressed, and for example, in the emotional distress damages charge, we specifically said
There is damages for invasion of privacy, and there's damages for emotional distress. And you will handle both of those in your emotional distress. Those will be included both in your emotional distress damages award. So we actually included that language in the emotional distress damages calculation. We already did that. In the CUTPA damages charge, the end of the CUTPA damages charge is damages due to the violation of the Connecticut Unfair Trade Practices Act are included in the other damages measures I am describing to you, and you will not assess them separately. So we actually addressed this as we did the charge, which I think is one of the reasons why I've been confused. I thought we were more on the same page than we were. So I do think that we have structured the charge so that there's two measures of damages. There's an emotional distress damages measure, and I'm sorry, Your Honor, I'm going to stop right here.
Well, I just heard the same thing so many times.
Yes,
I understand
exactly.
that.
So I'm not going to say it again.
I think we all understand it, but I don't want to backtrack now.
No, and I don't mean to do that, but I do think that we had, in the charge, we have gone a ways down this road in a helpful way.
So I think this applies to defamation per se, and CUPPA counts, and your verdict must be unanimous as to each. And I think that's pretty neutral.
Okay, Your Honor, we have to accept
I
the
understand.
as to each.
I understand. All right, what else?
I think that similar language needs to be included as to the other counts, that their verdicts need to be unanimous as to each count.
Where does it say that in the charge? I mean, it's inconsistent with the charge.
It's not,
I'm not understanding what you're saying. So
It's
now we've got the
black-letter law.
emotional distress damages. This applies to IED, false light, defamation per se, and CUPPA counts, same language.
Right.
Okay.
And
Well,
your
that,
verdict must be unanimous as to each count.
as to each.
Right.
Each.
Right.
Okay. All right. Then what?
Nothing for more from the defendant.
Your Honor, I think if we're going to proceed that way, the court's going to need to make a ruling about whether emotional distress damages are available under CUPPA.
And they aren't, in our view.
In our view, they are.
Well, that's a good point.
That's not a reason not to do it. No, I mean, look, I'm not the one who sued on behalf of 15 people under 4 different theories. But I am here to defend 2 entities who are entitled in this hearing in damages to pay no more than the jury unanimously finds them to be liable for. And the plaintiff's burden of proof is restricted on the allegations they've made in these various counts. And I will resist any effort to let the jury compromise on what they find as to each count.
Inventing, okay, I'm not going to say that, but if there's no legal support for what Mr. Pattis has said, and before we take a step, I mean, the verdict form is an important document, and it needs to reflect the charge, obviously. It can't be inconsistent, number one. Number two, it is going to be the one thing that we submit to the jury in writing that we are asking them to sign at the end. They are going to look at this form, and they're going to be guided by it. So, with respect, there needs to be legal support for what is being proposed here, not simply a statement, however earnest, by either of us. And there's no legal support, we submit, for the argument that Mr. Pattis is making. And that isn't, and you know, that's, again, I don't mean any disrespect by that, but an issue this important that has this much material effect on the verdict and the integrity of the verdict, I just am reluctant. Can this be the one thing that we hold over so that Mr. Pattis can supply us with whatever he's talking about, because we who have dealt with verdict forms in civil cases for a long time do not understand the concern, and we don't think there's legal support for it, despite the assertion that it is, quote, black letter law. We do not want to invite error. We got so far here in this case over years.
So what are you saying, Attorney Kotzko?
I just am saying I don't want to have this hammered out because we're all, we've been
Well,
at
so
this for a
far,
while.
there's nothing that we've said in the proposal that is contrary to the law, right? We're telling them what the damage is, what counts it applies to, and their verdict must be unanimous. They have to be unanimous in their verdict.
We're okay, but then you get into this idea where the unanimous as per count, and I believe, right. Yeah, so I think, their unanimity has to be on the damages total, but not by count.
That doesn't.
And Mr. Pattis says that's not true, and we say, well, show us the authority that says that's not true.
Well, I'd say the contrary to them. Show me where you
We can, we will.
Excuse me. Show me the authority that says what you're relieved of your burden of unanimity simply by pleading multiplicity. That is not the law, and I'd like to see the case that says it is. I don't come from a long firm with parents and grandparents involved in it. I'm not
All right, now we're
play that
getting
card.
personal here.
No, it is.
I don't want any more. I don't want any more. So let's just end it there with the personal attacks. And God, let's not engage in anything like that tomorrow. So,
Judge, because of the importance of this, and because it's the end of, it feels like the end of a long day. And
it's only 3 o'clock.
I know, but we're all feeling, I think, a little bit of cognitive, we need a cognitive break, I think. And can this be the only thing that we hold over so that we can, first of all, what we'd like to do is submit a proposal based on what the court has said so far, at least as far as we all agree. Because I think we all agree to a certain point.
What do we agree on? I'm not sure we agree on anything.
I think we are agreeing to put the direction in that these damages emanate from these counts, right? That's what the court wanted about, because we were going to say.
And you agree they must be unanimous.
Unanimous is okay too.
And you just agree as to each. You disagree as to each.
Right, I think that's where it goes.
All right, so why don't you prepare it and put the as to each in brackets, and we'll pick it up.
Okay.
All right, so where else am I looking on here? So now I'm on page 6. Attorney's award of attorney's fees and costs.
Yes.
What do you say, Attorney Pattis?
I stand on my interrogatory and ask that be submitted as a jury question. Yes, no, per count. Otherwise, there'll be compromise, potentially.
So you want it broken down for each plaintiff?
By count, yes. Because 3 may decide as to punitive damages, as to defamation. 3 may decide as to IED, and in that case, they'll say, well, we've got 6. That's unanimous, but that's relieving them of the
I don't
burden.
understand. I am not understand. I'm not following. Do it slower, if you don't mind. So, your concern.
On the question of punitive, on the question of punitive damages, my understanding of the law is that in order to obtain relief that they're requesting, the damages they're requesting, the jury must return a unanimous verdict. The jury must return a unanimous verdict on a theory of liability, in my view, that the plaintiffs have alleged. They've alleged 3 common law counts. In order to obtain an award of punitive damages, it is my contention that the plaintiffs must prove to the jury's satisfaction unanimously as to at least 1 count that they're entitled to punitive damages. And therefore, I'm requesting that the court consider a jury form that requires them to specify the count as to which they are unanimous. In the absence of doing so, 2 may decide that it was proven as to breach of privacy. Two different ones may prove that it was as to defamation.
Okay, now I understand what you're saying. Okay. I understand what he's saying. I didn't understand it the first time, but now I get it. That was very helpful. So if you reach a unanimous verdict on whatever, then
Yes.
yes.
Okay, so but
If
they
you
have reached.
if you reach a unanimous verdict on this, this, or this, check yes. That's it.
So, Your Honor,
That's
you
it.
have, there is a unanimous liability verdict in favor of the plaintiffs on every count and
Right.
on punitives.
Yes.
So how, I mean, I truly, and I'm trying to understand.
I suppose it would be
understand
if you reach a unanimous verdict that more than nominal damages should be awarded.
Yes.
That-
But I am not understanding now I understand that there could be an argument that for example, your false light claim fails. And so if your false light claim failed as a matter of law, right, then you would not be entitled to punitives under your false light claim, right? I'm trying to understand Attorney Pattis's position. But in this case, where we're entitled to punitives already,
$1 or more,
based on every single cause of action, right? It doesn't
$1 or more.
matter. It doesn't matter which cause of action. Every single one entitles us to punitives. So the idea of saying to the jury, you have to think cause of action by cause of action, it doesn't make any sense. And that's actually the issue that I'm having with the request for unanimity. There's already liability findings on every single cause of action. So the idea that they...
Right, but I understood that prior argument to be, well, they could believe that only nominal damages should be awarded on the defamation per se, but then, more than nominal damages on the intentional infliction. That's the...
Yeah, I get that too, Judge.
But, so this is different. So how can we make it clearer?
Okay, but let me try to address the prior point first. I get that distinction between...
I don't want to go back. I want to deal right now with the punitive damages. Because that's going to be easier.
Well, Judge, I don't think that it can be broken down count by count. I just don't think you can do it after post-default.
Okay, but so what we have here is, very basic. So let's try to give them a little more guidance.
Does the court mean by inserting the reckless, willful,
No.
wanton standard, or?
Well, I suppose we could. I just think it's getting very confusing for them. So somebody make a suggestion.
I think the suggestion would be, as to punitive damages, you find more than $1 or whatever that locution is going to be as to breach of privacy, your unanimous verdict is. As to defamation, your unanimous verdict is. As to IED, your unanimous verdict is. And then at least we know, and that is the sole concern I have, is that they reach unanimous sums as to the count they awarded on, so that we don't have a mix and match problem.
So you are basically want to say if you have reached a unanimous verdict on either IED or false light or defamation or CUPPA?
Yes.
Then?
So, Your Honor, that would be error. And the reason why is because they're not being asked to reach a verdict on CUPPA.
I couldn't hear you.
They're not being asked to reach a verdict on CUPPA. The CUPPA is decided. all that remains is the measure of CUTPA damages. And so it would absolutely be error.
As to the inclusion of cut, I would agree, but as to the others, not.
Right. So let me use a different example. You know, sorry, I can't say it again. Can somebody else say it? Sure, but what did I say before? Yeah. No. I mean, the idea that they're not reaching a verdict on intentional infliction of emotional distress. They're not. What they're reaching a verdict on is the amount of intentional infliction of emotional distress damages.
So then, ask them that question.
And the measure of those damages is described in the charge as the emotional distress damages, right? So as to punitives, what they're deciding is whether the willful, wanton, malicious standard is met as charged by the court. They're not deciding whether that standard
So if you find that the
based on
malicious blah blah blah
IIED,
standard has been met,
right?
Okay.
Then check yes. If you find it has not, check no.
But as to what? See, my claim is it has to be if you found that it was met as to IED, as to breach of privacy, as to not. Because if the answer, if there's no unanimity as to any of them, then the answer is no. But if it's 2, 2, and 2, then all 6 of them have found it, and their burden of proof has been diluted.
So, and I think what it has to actually be is if you find that the standard
has been met on any
as charged, because the charge basically the entitlement to punitive damages is already decided, and that's what the charge says, and then it describes the elements, and it says so. Then in your discretion you may award, but the truth is that the predicate for punitives is already established by the default.
However, there has to be unanimity as to the amount per count.
But there always has to be.
No, there
See, the court says yes, they say no.
No.
And then,
I think you're.
May I finish? There needs to be unanimity as to the decision to award it. In other words, to the amount. But that doesn't mean that there needs to be by count, because that's not what they're deciding. What they're deciding is whether to award or not. It's got nothing to do with the count. The reason why the count instructions are in, Judge, is because those actually establish the factual predicates that define the parameters of the hearing and damages. They're not being asked to decide anything under the liability and the descriptions of the causes of action that are in. And that's the disconnect we're having. There's no question put to the jury regarding whether they find IIED or whether they
All right, well, I sort of like the language, if you find that the malicious, willful, wanton standard has been met as charged, then in your discretion, and then have the checks. I think that's the best I'm gonna do on that. All right, what else?
I think that's it.
Yeah, I think then, right, we're back to just the unresolved verdict form, and we're going to make a proposal on that.
You don't mind, you're gonna draft it and circulate it?
Yes.
With what we just did, put the bracketed language that Attorney Pattis wanted and you didn't want, and that'll be the only thing we have to discuss tomorrow? Oh God.
I know, I'm running. My concern is, depending on how that goes, then there may be, as I described, there's parts of the charge that are set up in a particular way that we've already been over, and that would.
I don't think there's anything inconsistent with this and the charge. It just isn't.
Well, there is. There's the aspect of the CUPPA charge that says, you won't assess CUPPA damages separately.
CUPPA from that.
And I believe there's severe emotional distress charge.
So Attorney Pattis suggests removing CUPPA.
From taking it away as a
No,
count?
removing it from the description.
Portion, right.
Oh, I mean, that actually goes to the liability portion.
No, I had a separate interrogatory on the punitives. The court decided apparently not to give it because it's within the court's discretion, that it can be dealt with by a separate jury question. Here's my concern, Judge. It's 3 o'clock. We're apparently going to argue this until one of us drops, and it won't be me. And I've got closing arguments to prepare for tomorrow. If we're going to have further briefing, I'd ask that closing arguments be put off for a day. I don't have anyone else in the office working on this file, and I'd rather spend the next 6 or 7 of them preparing for closing arguments.
We're dealing with an issue that has no foundation. Respectfully, again, so this is a waste. This is taking up all of our time collectively at a time when we all have other things to do. I respectfully believe, I think that the court has indulged this argument way further than it needed to.
Right,
And
so
it's just being led right
the
there.
only thing that I have to think about is the bracketed language as to each.
We will
So
submit
so
that.
what time do you need to know by? And don't say in the next 5 minutes, because it's not
No,
gonna
by
happen.
tomorrow morning. I mean, I think we're gonna have to put it together. We have to go back, put it together, submit it to the court, because we don't have our ability to do that right here. We'll do that. Alan, what do you think?
I just want to repeat to the court, if the court were to do count by count, then we would need a ruling on whether.
The only thing that is left at this point, I'm with you, Attorney Pattis. Mentally, my bag is packed. Mentally, my bag is packed, and I've started my car in the parking lot.
Didn't start.
So the only thing that is left is the bracketed language as to each. That's it. So that's the only thing that I'm going to think about. Otherwise, we've laid it out over and over again. Do you want me to read it one more time?
No, I have
Okay.
it, Judge, but if the court is going to charge count by count, then we will need.
Well, if you're saying if the as to each language is included, because that's the only thing. As to each is either in or out. It's
Well,
3 words.
I think if the court is going to, I think that we have a contested issue about whether emotional distress damages undercut but go to the jury.
Okay.
And so I think we also need a ruling from the court on that.
Okay, and I will rule that they do go to the jury.
You will rule that they do.
Yes, in your favor. Okay, so now what?
So now we have as to each.
So that's it.
Yeah, I mean, what remains is the court's decision as to each.
Right, okay, so that's not gonna hold anything up, so you're going to circulate this, and I'll let Ron know before 5, and then he can email you, all right?
Thank you.
We're adjourned.
Thank you, Alan.
All right.